where transformation begins. When labor where transformation begins. When labor evolves, justice and equity. Education Labor Relations Council Labor Law Seminar 2025, where transformation begins. When labor evolves, justice must lead. South Africa's labor terrain is shifting faster, deeper, and more complex than ever before. And when the landscape changes, leaders must rise. Join us from the 11th to 13th of August 2025 at Empress Palace in Johannesburg for the Education Labor Relations Council Labor Law Seminar, under the theme, Adapting to an Evolving Labor Landscape to Promote Social Justice. It's a strategic gathering of policymakers, union leaders, educators, and legal experts converge to chart the future of work, rights, and equity. Education Labor Relations Council Labor Law Seminar 2025, where transformation begins. When labor evolves, justice must lead. South Africa's labor terrain is shifting faster, deeper, and more complex than ever before. And when the landscape changes, leaders must rise. Join us from the 11th to 13th of August 2025 at Empress Palace in Johannesburg for the Education Labor Relations Council Labor Law Seminar, under the theme, Adapting to an Evolving Labor Landscape to Promote Social Justice. It's a strategic gathering of policymakers, union leaders, educators, and legal experts converge to chart the future of work, rights, and equity. Education Labor Relations Council Labor Law Seminar 2025, where transformation begins. When labor evolves, justice must lead. South Africa's labor terrain is shifting faster, deeper, and more complex than ever before. And when the landscape changes, leaders must rise. Join us from the 11th to 13th of August 2025 at Empress Palace in Johannesburg for the Education Labor Relations Council Labor Law Seminar, under the theme, Adapting to an Evolving Labor Landscape to Promote Social Justice. It's a strategic gathering of policymakers, union leaders, educators, and legal experts converge to chart the future of work, rights, and equity. Education Labor Relations Council Labor Law Seminar 2025, where transformation begins. When labor evolves, justice must lead. South Africa's labor terrain is shifting faster, deeper, and more complex than ever before. And when the landscape changes, leaders must rise. Join us from the 11th to 13th of August 2025 at Empress Palace in Johannesburg for the Education Labor Relations Council Labor Law Seminar, under the theme, Adapting to an Evolving Labor Landscape to Promote Social Justice. It's a strategic gathering of policymakers, union leaders, educators, and legal experts converge to chart the future of work, rights, and equity. Education Labor Relations Council Labor Law Seminar 2025, where transformation begins. When labor evolves, justice must lead. South Africa's labor terrain is shifting faster, deeper, and more complex than ever before. And when the landscape changes, leaders must rise. Join us from the 11th to 13th of August 2025 at Empress Palace in Johannesburg for the Education Labor Relations Council Labor Law Seminar, under the theme, Adapting to an Evolving Labor Landscape to Promote Social Justice. It's a strategic gathering of policymakers, union leaders, educators, and legal experts converge to chart the future of work, rights, and equity. Education Labor Relations Council Labor Law Seminar 2025, where transformation begins. When labor evolves, justice must lead. South Africa's labor terrain is shifting faster, deeper, and more complex than ever before. And when the landscape changes, leaders must rise. Join us from the 11th to 13th of August 2025 at Empress Palace in Johannesburg for the Education Labor Relations Council Labor Law Seminar, under the theme, Adapting to an Evolving Labor Landscape to Promote Social Justice. It's a strategic gathering of policymakers, union leaders, educators, and legal experts converge to chart the future of work, rights, and equity. Education Labor Relations Council Labor Law Seminar 2025, where transformation begins. When labor evolves, justice must lead. South Africa's labor terrain is shifting faster, deeper, and more complex than ever before. And when the landscape changes, leaders must rise. Join us from the 11th to 13th of August 2025 at Empress Palace in Johannesburg for the Education Labour Relations Council Labour Law Seminar, under the theme, Adapting to an Evolving Labour Landscape to Promote Social Justice. It's a strategic gathering of policymakers, union leaders, educators, and legal experts converge to chart the future of work, rights, and equity. Education Labour Relations Council Labour Law Seminar 2025, where transformation begins. When labour evolves, justice must lead. South Africa's labour terrain is shifting faster, deeper, and more complex than ever before. And when the landscape changes, leaders must rise. Join us from the 11th to 13th of August 2025 at Empress Palace in Johannesburg for the Education Labour Relations Council Labour Law Seminar, under the theme, Adapting to an Evolving Labour Landscape to Promote Social Justice. It's a strategic gathering of policymakers, union leaders, educators, and legal experts converge to chart the future of work, rights, and equity. Education Labour Relations Council Labour Law Seminar 2025, where transformation begins. When labour evolves, justice must lead. South Africa's labour terrain is shifting faster, deeper, and more complex than ever before. And when the landscape changes, leaders must rise. Join us from the 11th to 13th of August 2025 at Empress Palace in Johannesburg for the Education Labour Relations Council Labour Law Seminar, under the theme, Adapting to an Evolving Labour Landscape to Promote Social Justice. It's a strategic gathering of policymakers, union leaders, educators, and legal experts converge to chart the future of work, rights, and equity. Education Labour Relations Council Labour Law Seminar 2025, where transformation begins. When labour evolves, justice must lead. South Africa's labour terrain is shifting faster, deeper, and more complex than ever before. And when the landscape changes, leaders must rise. Join us from the 11th to 13th of August 2025 at Empress Palace in Johannesburg for the Education Labour Relations Council Labour Law Seminar, under the theme, Adapting to an Evolving Labour Landscape to Promote Social Justice. It's a strategic gathering of policymakers, union leaders, educators, and legal experts converge to chart the future of work, rights, and equity. Education Labour Relations Council Labour Law Seminar 2025, where transformation begins. When labour evolves, justice must lead. South Africa's labour terrain is shifting faster, deeper, and more complex than ever before. And when the landscape changes, leaders must rise. Join us from the 11th to 13th of August 2025 at Empress Palace in Johannesburg for the Education Labour Relations Council Labour Law Seminar, under the theme, Adapting to an Evolving Labour Landscape to Promote Social Justice. It's a strategic gathering of policymakers, union leaders, educators, and legal experts converge to chart the future of work, rights, and equity.
these meetings. And there were some who were insisting that we should return. And I said, after having seen the savings that we are making in our budget, it's just not justifiable. It's only when it's necessary that we will get together like this. And saying that, I think I should start off by saying, if you are here on time, it means you care, or you didn't trust the traffic. Either way, you are welcome. And you can tell by the empty seats that some took a chance, and as a result, they are not here. Thank you once more for supporting our program, which is running for the second year this time, which forms part of our celebration at JP. We've been in existence for 31 years. I don't know how many in this room know that the ELRC predates the promulgation of the Labor Relations Act. Can we please get a round of applause for that? We do understand and appreciate that your schedules are busy, but once more we appreciate you having made time to come. We are joined by impressive lineup. The JP will be introduced by our chairperson shortly. The specialists and practitioners in the labor law and governance, academics from universities across the country, leaders of teacher unions, our clients, the full-time shop stewards and the negotiators, the heads of Provincial Department of Education, the senior management from both the Department of Basic Education and DPE. How can I forget Murik, the real Murik, who has funded this event? Without them paying, we will not be here. DPE, the TVGC, which is also an employer within the scope of the council. Colleagues, this gathering comes at an important time in our country where we are honoring women whose lives have been defined by leadership, public service, and the pursuit of social justice, as we continue to fight for gender equality in South Africa and the world as a whole. Not only are we celebrating the Women's Month, which, by the way, we should be celebrating women for the whole year. Not only are we celebrating women in the country, one of the crucial and one of the key events that is going to be part of us in the history of the country, we convene at the time as we prepare for the G20 Leaders Summit in November this year, which is a historic moment for us, as it is the first G20 summit to be held in South Africa, and South Africa is the country holding the chair of that for the first time in the history of our existence as the country. I think that also deserves another round of applause. We also happy to note the theme of the summit, that it's aligned to our gathering today. The summit, the theme is solidarity, equality, and sustainability. It is aligned to this summit, which is in the same spirit, the seminar, the same spirit that is about bringing people together, fostering collaboration, and working toward practical solutions for the challenges in our labor landscape. Part of my job was to welcome you and introduce the MC, and I don't think the MC needs any introduction because he has already taken over my space. Colleagues, welcome, and we hope that you will enjoy the meaningful contributions that shall ensue in the course of our 3-day program. Thank you very much.
Thank you very much, General Secretary, for that warm welcome there, ladies and gentlemen. Once again, my name is Mxolisi Masango, and I'm a South African TV news anchor as well as a talk show host. Thank you so much for having me navigate these very important conversations with you. I must say it's always my favorite part of the year as well, just being part of the ELRC seminars, because this is where we all get an opportunity to really have meaningful conversations and where we have some of the brightest brains in our country come under one roof together. It's just something I marvel at all the time. So ladies and gentlemen, without any further ado, ado, I would like to call upon the chairperson of the Elrc, Dr. Bono, to introduce the keynote speaker for us this morning.
Clearly, I'm better than others. Ladies and gentlemen, esteemed guests, the JP, the DG, the HODs that are here, the social partners to the ELRC, principals of unions, and all esteemed guests that have blessed us. I've been asked to introduce the Judge President of the Labour Court and the Labour Appeal Court. It's a real privilege to introduce someone who has helped shape the very foundations of labor relations in South Africa, a true heavyweight in the labor law arena. The JP is no stranger to us. He was the chairperson of the Public Service Coordinating Bargaining Council, but that's just one highlight in a career packed with achievements. Judge President Molahle has literally done it all, I believe. From being the first executive mayor of the West Rand District Municipality to leading the CCMA, mediating for Tokiso, as well as IMSA, and serving on the board of the Legal Aid South Africa. He's a dynamic and multifaceted leader who's worn many hats, both in politics, government, and labor dispute resolution, and has excelled in all of them. We are very fortunate to have him here today, bringing unmatched insight and decades of experience. I have to mention this, and I said to him when I walked in, that I saw that on the program, it is not written that he chaired the ESC Tando. So as the chairperson of the ESC, I have to highlight that he is also chaired the ESC. Ladies and gentlemen, let's give a loud and warm welcome to the Judge President of the Labour Court and the Labour Appeal Court of South Africa, Judge President Molahle.
Will I be able to put this here? Good morning, ladies and gentlemen. I will stand on the protocol set by both the Secretary General and the Chairperson, but let me acknowledge the presence of the DG and everybody who's here, some of the colleagues that I, through my working life, has come across, and we worked well. And to also say it's really a pleasure and a privilege to come before you. If I may formulate it in a Setswana, and I hope everybody now, after 30 years of democracy, will be able to hear. I'm not going to expect you to speak the language, but I can hear all the 11 languages and I can communicate back. I'm not the best communicator, but if I'm faced with having to nishibulabule, nitabulabule shangana. If kufuneka kuti ngikhulume ngizokhuluma. If kufuneka kuti ngithethe, hawu ngizothetha madoda. As dat niedag is om dat ek moet praat, ek sal ook praat. But in Setswana there's a saying that maruping go a boelwa, go sa boelweng ke teng. Basically, I'm saying I feel very welcomed and I feel back at home. I had my own share of interacting with the ELRC at the time when we were establishing the PSCBC and all other bargaining council. So it is really a greatest pleasure for me to be with you today and to share with you some of my thoughts about the theme that you've set up for this seminar. When I looked at the theme at the beginning, and let me also, before I go too far, let me wish all our women a happy Women's Month and free from GBV. As men, let us commit ourselves to ensuring that women have a peaceful month as a starting point of this month, but going forward into all the coming years and days, that we stay away from violence against women and our partners. As I say, when I received the invitation, I pondered around what exactly is expected of me in looking at the topic. The first thing that came to mind was maybe I should speak about labor relations in the public sector, to look at how, for a history in South Africa, educators have been treated, and in as far as labor relations is concerned, or to look at the broader labor relations in the country. And for me, the theme then suggested that at this particular stage, it's appropriate after 30 years to locate your theme within the historical development of Labor Relations Act, more particularly to remind ourselves that we should not go back. And not go back does not necessarily mean reintroducing the apartheid laws as raw as they were. But those laws can be reintroduced in different ways. They can be reintroduced in ways that relates, for example, undermining the vulnerable groups in our society. And therefore, our history is quite important. And you would have seen, and I'll touch on it as we go forward, that not so long ago, in fact, the Constitutional Court had to rule on the question of domestic workers. And you ask yourself, for all these years, how come our legislatures never picked up that this group of people or categories of employees that have always been vulnerable and abused, discriminated, exploited, have not been considered in the development of our labor laws? It is both an honor and privilege, as I've already said, to address you today on a journey that traces an evolution of labor justice in South Africa, a story that weaves together the strands of law, struggle, social change, and democracy. This history is not merely about statute and courts. It is a story of a nation's quest for fairness, dignity, and inclusion within its workplaces and society at large, with a vision born in the struggle to promoting social justice. The Native Labor Regulations Act of 1911 and the Industrial Conciliation Act of 1924 as legal instruments that entrenched racial segregation in the workplace and denied millions of the most basic labor rights. Collective bargaining, the right to strike, and the fair labor practices were privileges reserved for the few, while many were deliberately marginalized, excluded from legislation that governed labor relations. The design was based on a rigid and dualistic labor system which reflected the wider policies of apartheid which perpetuated inequality and social injustice. The system was not without its own contradictions, which beneath its surface of repression actually generated and stirred a growth of forces that were determined to resistance for the assistance of the working people and would not give up fighting for the recognition of their dignity and the right to be respected. The 1970s were a turning point marked by profound economic, political, and social upheavals. South Africa faced slowing economic growth after the global oil crisis and recession. In the streets and factories, the fight for justice intensified. The Durban strikes in 1973 are but one of an example that shook the very foundation of the oppressive system that actually woken up the apartheid system. If you look at from 1973 onwards up to 1976, 1979 in particular, when the Vihan Commission was introduced, it tells you what happened in the early 1970s. Against this turbulent background, the government appointed the Vihan Commission in 1977, a commission with complex and contradictory mandate to stabilize labor relations and facilitate economic growth, but within the system still define the control and racial division and subjugation and exclusion of some of the vulnerable groupings such as domestic workers and farm workers. Well, South Africans, it looks like we've got a very strong and entrenched use of commissions to resolve our problems. So we do have that history. The Vihan Commission managed to recommend that in 1979, presented some form of a progressive and pragmatic approach. It's not without its criticism, and I've seen some scholars suggesting that the Vihan Commission was the most successful outcome ever to have happened. I do not agree, because if it was, we would not be seeing some of the cases that come before the courts relating to how people are being treated. It would have addressed those particular issues, particularly the exclusion of certain groups of workers. The public servants came into the labor relations system very late in the day. We know about the Public Service Labor Relations Act. The first time black trade unions were legally recognized, offering workers a legitimate voice in the industrial arena. The establishment of the industrial court provided tribunal to arbitrate disputes and develop labor law jurisprudence. And maybe if I can just jump back a little bit, those of you who read in the history of labor relations, you will recall that in 1922, there were several strikes in the country, mainly in the mining sector by the white mine workers that resulted almost in a civil war. And that led to the change and amendment of the Act in 1924 to try and deal with disputes at work. But that excluded the African and other black workers from the system. And you will also recall when 1979, there was an embracement of all trade unions. There were some unions which were opposed to that integration of all unions into this one system. For SATU, for example, people were divided as to whether trade unions should be required to register. The Industrial Court was created in 1979, October, and was permanently based in Pretoria. After 1985, the Industrial Court then created further industrial courts that would sit permanently in Cape Town, Durban, and Port Elizabeth, and that legacy seems to have followed, which is also, again, a dent in our democracy in as far as access to the courts are concerned. We're still sitting on 3 courts, and to think of it, that somebody in George has to travel to Cape Town to go and institute the case, That, I'm told, is about 400, 450 kilometers. Somebody has to travel. The other day in court, I received the information that somebody traveled all the way from Oudtshoorn to Johannesburg. And the workers at the court then came to me and said they're collecting donations because this person had traveled all night and only to arrive in Braamfontein and to be told, your case is postponed. Now, that for me still tells that the system is still lacking in as far as addressing some of the problems. The industrial court comprised of 13 members in Pretoria, which was based in Pretoria, and had 5 members sitting there, judge president and the president. And I may pause to indicate that the industrial court was not the court in the true sense that we understand what a court is. It was more of a tribunal, but given this name, industrial court. The representation in the industrial court seemed to be one that was mainly male, in fact, it was male-dominated, and to a very large extent from the very beginning, it was all white, until at the point when they appointed member Bulbulia, and later on, they appointed a female white presiding officer, Ms. Duff. But for the rest of it, the system was based on white male domination. The Industrial Court implemented the Industrial Conciliation Act of 1924, which was later amended to the Industrial Conciliation Amendment Act in 1956, and later that act was amended to be called the Labor Relations Act. This legislation regulated trade unions and labor relations during the apartheid era. It established mechanisms for prevention and settlement of disputes between employers and employees, but also of importance when you look at the Act and look at where we are. The Act still talks about conciliation, and conciliation was the most emphasized process that was used. Those who are old enough to remember the industrial court, you will recall that if there was a dispute, what conciliation meant was simply to go to Pretoria, mainly those of us who are in Gauteng. You come before the chairperson of the conciliation, and all what he will ask you is there a dispute? Employer, do you want to take the employee back? No. Employee, what do you want? I want to be taken back. Conciliation failed. And that's the system we had. The industrial court, in applying legislation, developed a very progressive jurisprudence, particularly in the areas of the definition of labor practice and the concept of discrimination. It interpreted this legislation in the context of the Convention of International Labor Organization under the international law of discrimination, which prohibited any discrimination that is impermissible or impermissible reason. I may pause here and say some of us were at the time we were very young, and you know how young people always are creative and can think above what they can punch. I was one of those who were saying, why do you change the definition of the unfair labor practice? Because it was very wide, and it provided for almost anything that would be unfair at the workplace. But be that as it may, we'll see how the system has developed since the bringing in 1995 of the Labor Relations Act, in as far as the unfairness of treatment at the workplace is concerned. Some of the interesting cases that the industrial court handled, firstly, in the Chamber of Mines and Council Mining Union in 1990, the industrial court found that the employer had discriminated against black employees in not granting them the same terms and conditions of employment as those of white counterparts. In other words, this treatment of black workers was assumed to be an unfair labor practice. Now you can see how broad the unfair labor practice concept as was used in the industrial court era. In Biela and others versus Snella Enterprise, the industrial court found that the dismissal of African workers and not Indian workers was not discriminatory. Now, that's quite an interesting one, and you would immediately, when you see that and say, on the face of value, there's discrimination between the Indian workers and the African workers. But what the court did was to look at the context in which the dismissal took place. It took place in the context where the employer had issued an ultimatum, and the Indian workers complied with the ultimatum as opposed to the black workers. Now, one of the other very important cases that came before the industrial court and ushered really long-term vision in as far as jurisprudence is concerned is the case of G versus K in 1988. The industrial court dealt with discrimination in the context of a female employee having an affair with a married director of the company. I had the opportunity where I worked that the company was involved in this case, and I followed with interest as to how it was going. And I remember some of the discussion was like, are we going to make it? Will we succeed? But this case is quite an interesting one because the two directors ran a company that was involved in research. One of the directors had an interest in this young researcher. The young researcher was not interested, and he developed a very nice plan when, I think it's when they were conducting the so-called colored elections in the Cape. He then designed a system of sending him to the Cape to go and research there. And well and behold, as he arrived, he also arrived. So you can then draw your conclusion. But then they had this affair that ran for some time. They would go to parties together with their partners and disappear and whatever. But then the wife of the director discovered. The wife of the director then went to the other director and said, listen, this woman is not a good woman. She's got bad morals, and she's putting your company into disrepute. The two directors convened a meeting. They took a resolution, as a board would do, to say, yes, indeed, you are a terrible woman. Why do you have an affair with a married man? Now, it's interesting because now we're not talking married men, we're talking also married woman. So they dismissed her for bringing the company into disrepute. And the industrial court found the termination of the employment relationship on the grounds that the former employer-employee relationship was a source of embarrassment, was fundamentally unjust and discriminatory. Now, I know what happened later on after the judgment was issued, but I thought, appearing before teachers, in our days we used to call it a recitation, and we were forced to memorize. Now, these days they call it a poem. Now, the Leonard Bulbulia, in writing the judgment, he I'm not sure whether the message was sent to both the parties or to one of them, but I'm inclined to think that he was really directing the message to the man. He writes, and he quotes from a Roman poet, Catullus, and he says, and I quote, "The kiss I stole when thou and I, dear girl, were romping in the glade, did nectar in its sweet survive. But oh, how dear for it I paid." So that really tells how Bulbulia, in his way of looking at the whole concept of justice and fairness, approach matters. And those who are interested, I would say to you, if you can go and look at some of the jurisprudence that was developed by Bulbulia, you would be fascinated. In J versus M, LTD, the industrial court held that whether sexual harassment is between members of the same or opposite sex is a serious matter, and also depending on the form it takes, it affects the integrity of the body and the personality of the victim. Now you look at that, you look at our constitution, how it emphasizes dignity. Clearly what the industrial court was saying there was dignity is actually of importance. So when you sexually harass any person, be of the opposite sex or the same sex, it is bound to denigrate the integrity of that person. Another critical case in the development of anti-discrimination jurisprudence in the industrial court era was the Association of Professional Teachers and Another versus the Minister of Education. That was in 1995. Should fall under the labor, I can't recall now whether it fell within the new labor relations. I think, no, it was still under the old act because it was an industrial court case, where the court addressed the issue of whether a married teacher, woman teacher, was entitled to a home allowance. The court found that the disqualification of a married woman teacher from receiving a home allowance amounted to sex discrimination and was therefore an unfair labor practice. And again, the court there was very critical about the legislature, and I think when you read the case, you'll pick up that one of the arguments was that there are no resources available to provide. And it was, no, I'm sorry, I'm actually confusing it with the next case. The court basically said, no, you can't. You basically can't discriminate on the basis that because she's a woman, and therefore she'll be married to a man, she's not qualified, only the man would qualify. Now, as I said, the history of South African labor law is more than a legal narrative. It is a reflection of the country's broader struggles and triumphs. From exclusion to inclusion, from control to rights, from fragmentation to unity, the arch of labor justice parallels the arch of South Africans' path to democracy. Our courts today stand not only on the arbiters or as arbiters of law, but as guardians of dignity, fairness, and social progress. And I think this aspect is something that academics must always hold us, particularly judges, to account. If we are to deviate in our interpretation of the law, criticism must be brought up. And progressive criticism must be presented to ensure that as we think and we apply our minds to cases, we take this principle into account. They remind us that the law is not static. It is a living dialogue between the aspirations of the workers and the structures of power. And DG, unfortunately, I'll say to you, you are a structure of power. And as you implement the law, the workers and the unions will take you on. In light of, and let me also emphasize, as I say, also including us as judges, it would be naive to think that we don't wield power. As we sit there, I can tell you, I wield enormous power, not only sitting in court, but as I write my judgment, I've got to think about how to approach certain issues. And if you're going to simply accept that the courts are superior next to the Constitution, I think we may have a slippery slope. So therefore, I would say we would always welcome criticism in as far as judgments are concerned. In light of the democratic election that took place on the 27th April 1994, the new democratic dispensation undertook to draft a new constitution that would be inclusive of everybody's rights, regardless of race, gender, sex, age, etc. The new constitution was dated 19 September 1996. The constitution then came into effect 4 February 1997. The new constitution also included rights pertaining to, and you can find those rights under section 23 of the constitution. But fundamentally what it does, it provides that everybody has got the right to fair labor practice. And I would want to say, DG, as I said, it is not for the unions or the workers to raise an issue and say, this is undermining our right. It is for the employers also to progressively engage where you pick up that certain things may be wrong, that you need to come in. How many of the employers, I see I've got stairs to walk here. I wonder what would have happened if I came here with a broken leg. That would have been a big challenge, isn't it? Now, for me, that is the issue and the fundamental issue. Let me share with you my experience as a mayor. Those days, PFMA wasn't as enforced as it is. There was some flexibility. And I walk in at the Western District very early in the morning, and I see this person who's coming to seek service delivery. He's wheeling on his wheelchair, and he's faced with the stairs. They were almost the same as this, not about 4 or 5. And I immediately went to the municipal manager and I said, well, look, that person seems to have nobody to help to come up. Why is there nothing done? And my attitude was, this involves about 150 rands. This involves 4 bags of cement for you just to do the slope. And I said it must be done. And I'm glad I went there many years later and I saw that is still being used. But how many of us would come up? And DG, I'm saying this because I came across, now I must share this with you. I came across a case in the early days before I moved to the High Court, and it was from the Department of Education, Nogal. But this case had nothing to do with disability. Oh, no. The next case that was coming up had to do with disability. I'm not going to go into the merits of the case. It's gone on since then. It's 10 years, 15 years since I was there. And this particular litigant, his chance had not yet come. And he raised his hand, and initially I thought, the tradition and culture in the courts is you only listen to lawyers and you ignore everybody else. And something said to me, but is that right and is that fair? So I called on him and I said, what is your problem? And he came forward, he says, I can't remember, I think somebody had said something about equality and whatever. And then he says, Judge, if you had broken your leg this morning, would you have been able to come and hear our case? And I said, why? He says, because there are no ramps here. You probably would not have come here. And then I realized later when his case was called, that his case was, he was fighting the whole issue of fair treatment of disabled people at schools. I don't want to go into the merits, and I don't think they are relevant, but all I'm saying is, it's not only for the affected people to complain, it's for us as employers and us who have got the power in the new democracy to take initiative sometimes and say, what's happening? So I think that for me is quite critical. How many of you would, if you have disabled people that use the wheels, find out what happens if there is fire? How are you going to get them out? I learned about it not so long ago, about 2 months ago, when I saw one of our disabled persons driving into the lift with a wheelchair. And I said to the manager, tell me, if there was fire, it keeps saying don't use the lift if it was fire. What happens to this? Unfortunately, the labor court in Braamfontein has a facility. They have those special wheelchairs that can go down the stairs. I went to Durban and I said, where is that? It's not there. But the point I wanted to emphasize is, it is quite important that we do not seek our power and use it as a shield to say nobody can tell me what to do. In the case of National Education, Health and Allied Workers Union versus the University of Cape Town, the Constitutional Court stated, and I quote, The concept of fair labor practice must be given content by the legislature and thereafter left to gather meaning in the first instance from the decisions of the specialized tribunals, including the Labor Appeal Court and the Labor Court. And this is the point I made, that as we make meaning to those provisions, we also as judges need to be critical or criticized if we deviate from this fundamental principle. These courts and tribunals are responsible for overseeing the interpretation and application of the LRA, a statute which was enacted to give effect to Section 23 of the Constitution. That's a section that provides for all the rights of both the employer and the employees. I'm not going to read the whole of it because of time. The Constitutional Court, in the certification of the Constitution of the Republic of South Africa in 1996, said the following: the primary development of this law will, in all probability, take place in labor courts in light of the labor legislation. That legislation will always be subject to constitutional scrutiny to ensure that the rights of workers and employers as entrenched in the law is honored. Now, to use an example, most of you who participate here will know about Sidumo. Now, before Sidumo, the Labor Court, the Labor Appeal Court, the Supreme Court of Appeal, all of them said the determination of whether an arbitration award should be reviewed or not is rationality. And the Constitutional Court, in upholding what it has already said here, then overruled that and said, no, it's not rationality, it's reasonableness. It's tested on the question of whether a reasonable commissioner could have concluded that particular decision made by the arbitrator. Today, as we reflect on the profound role played by the courts in advancing and safeguarding the rights, dignity, and fairness owed to every worker in South Africa, the Labor Court is not merely a judicial body. It is a guardian of equity, a bulwark against injustice, and a beacon of hope for those who might otherwise be silenced or marginalized in the workplace. In Mahlangu and another versus Minister of Labor and others, Commission for Gender Equality and another as Amici Curiae, the case dealt with the issue of how domestic workers were. Part of the case are also quite painful in that Ms. Mahlangu was a sighted person. I don't think he was total, and she drowned. After her death, the daughter then applied for the benefits under COEDA. And this was discrimination and against the principles of the Constitution. The court found that there was no legitimate objective question of the resources. Now, for me, if you say the lack of resources, then exclude everybody. If that argument is to say, then exclude every other employee. On what basis are you excluding domestic workers? In fact, I would say, rather exclude those who are in the upper echelons, those who are earning sufficient to can take insurances and medical aids, and not those that can hardly afford to even pay for a taxi to go to the hospital. Well, include the employee on the basis of available resources constituted a direct infringement of Section 27(1), read with Sections 27(2) of the Constitution. So this case exemplifies the importance of protection well, that the labor court's courageous and principle-driven judgments built trust in the labor relations system It empowers employees to stand up against unfair. Guardian of labor rights, the cases referred to above, stands as a vital testament of the direction that our society has taken, where we are in terms of ensuring that there's access to justice, that equity applies in the workplace. Court is concerned. I'm sure most of you would be aware that the Labor Court, like all the other courts in South Africa, have adopted that approach is an approach which actually had been endorsed by the Nation Development Program, which described digitization of address discrimination and mainstream gender equality. Now, we introduced, or let me start off by saying, the case line system was introduced in Gauteng as a pilot project. And for those of you who are in the labor relations may start questioning, why now after case lines, you're now going back to court online, a system that's much more onerous, I wouldn't say complicated, onerous than case lines. What happened was the solution which we had asked for was a single solution, one-to-one solution, which included both court online and case lines. So initially they were supposed to develop court online, and then once court online is completed, they would then conclude case lines. Court online is evidence collection system. It collects all your documents, your notice of motion, your answering affidavit, and all those necessary documents. Once all of them have been complied, and the case is ripe to be heard by the judge, it then transforms into case lines. Case lines is more adjudicative evidence-led process, and that's more of a judge process. There's more of a judge process. There's a judge who gets into that. And so that's where the difference between the two is concerned. But so far, we have implemented court online. There are some teething problems, but the problems are not necessarily the system. There is also human learning that we're going through in as far as that system is concerned. But also it's one of those problems. You know, society from wherever it comes fascinates me. I still ask myself where and who designed the system that if you're a woman and you get married, you must change your surname. But men, you don't change your surname. Now, what technology does then to us, if you, before you get admitted as an attorney or as an advocate, you are Miss Lekhatli, and then you get married to Mr. Bota. Now, suddenly when you open your practice and you say, I now want to register, the system says, we don't know you. Because your now name you are using Bota and not Lekhatli. So those are some of the challenges that we find in the use of the system, but we have, our technicians have been looking at it to see how it can be resolved, because it does actually impact on the whole process of access to justice. So in conclusion, I would say, so far as we are, the Labor Relations Act has done us good service. It is a system that I believe all of us should support. It is a system with our democratic processes that requires regular attention and review. And as you may be aware, there is a proposal to amend the Act. Certain areas of the Act requires amendments. There's some delays in terms of finalizing that, but I'm hopeful that sooner those amendments will come through. And more importantly for us as the court is the amendment relating to the question of whether judges of the labor court should be allowed to act in the labor appeal court. It's a system that puzzles my mind how our legislature arrived at that conclusion, but they were informed by the context and the circumstances at the time. But when you look at it, we are very thin when it comes to people with experience in the labor arena. It's a very highly specialized area, and it does require judges that are highly specialized. Now, if, for example, if I didn't move to the High Court and I remained in the labor court, today I would have been 18 years in the labor court, but disqualified to go and apply the skills and the experience that I would have picked up in the 18 years, right? I mean, there are 3 judges, that have been there for over 15 years. But I can't ask them to come and act in the labor appeal court. I can go and ask a judge in the High Court who has never actually done labor law to come and sit in the labor appeal court. Do you see the kind of contradictions that we faced with? But as I say, the good news is that those in charge are busy at NETLEC finalizing to address that particular problem. Well, also to share with you some of the contradictions. You can now, as of 2 years ago, 2024, as a labor court judge, you can apply, you can't act in the labor appeal court, but you can apply to be appointed in the labor appeal court. So, do you see a little bit of the contradiction there? You can't be, an intern, if I may use that concept. You can't be an intern, you don't qualify to be an intern in the labor appeal court, but you qualify to apply straight. So before we even impart the skills, you can move on. So it is one of those criticisms that has been leveled against the Act. But otherwise, good people, thank you very much again for affording me this opportunity. I hope I have put on the table some discussions that you can take forward in your deliberations. And may I also take this opportunity to wish all of you a very enjoyable, fruitful seminar in the next 2 days or so. Thank you very much.
JP, can I ask you to also just grab a seat because we're going to engage on your presentation. Yes, thank you very much for that insightful presentation, JP. Anyway, can even grab that seat there. So, ladies and gentlemen, we've just heard from the JP now. Just a quick one on our house rules before we proceed. I know you're also making notes there as the JP was giving out his keynote address, so we'll give you an opportunity to engage with him in just a moment. We'll have our roving mic, which is going to be on the floor. Just a quick one on the housekeeping rules. We have charging stations. If you're running out of battery life, there are charging stations just behind us, there by the entrance side where you'll be able to get a power bank that will enable you to charge. Also, we have some exhibitors at the foyer where you're going to get a chance and an opportunity to go through some of their stands and what they offer there. And to my presenters that are coming up, I am going to be very strict with time because we need to get through as many presentations as we can. So we've got a bit of a time allocation also on the program. It's not a guideline. It's something that we must stick to, ladies and gentlemen, as we proceed. So, and also, bathrooms are also just behind us. If you go straight from there, you go shoot straight up. And LexisNexis, one of our presenters that are coming up shortly, has a very interesting book that you can access through that site. So I'm going to ask you that you check out their website there. You'll be able to access that book. Also, there'll be a juta stand outside that I've been told, which is going to be carrying out a raffle on the last day. So you can just visit their stand after this. There are some nice prizes to be won there. And also, to my presenters, can I ask that you get in touch with the lovely lady to my left, Bernice, there, if you haven't handed in your presentations, because this makes things easy for us to be able to access your presentations after you are done. And just a quick one on those presentations, they will be made available as soon as the speaker is done with their presentation. And also, this moment is being live streamed on the ELRC's YouTube, Facebook page, as well as on Twitter. So I encourage you to just let all your constituency know this is where it's happening this morning. So we are just about to get into our engagement with the JP, ladies and gentlemen. And I'm going to ask all the hands on the floor, just so I take note of them. But let's see, any questions from the floor? Okay, I'll get things started, JP. I'll get things started. It seems like, oh, we have one this side. Can I get the microphone to the gentleman there on that side? But in the meantime, JP, while we get that microphone, I know you've touched on a lot of things, and a lot of themes also came out throughout your presentation, which was quite informative. And I think something that has set the public discourse on a frenzy over the past couple of months is one point that you made about the tendency of us in South Africa to make use of commissions to address our problems. Being in the news space, that has been something that has dominated the discourse. So in your view, do you think these commissions genuinely help resolve systematic problems, or do they risk becoming a way of delaying real change, which is something that we really need? And how can we ensure that they lead to concrete action rather than just, producing reports in a way?
Yes. No, well, look, commissions, as I said, have been used over the period in South Africa and other countries. Some scholars would say commissions of inquiries are used to water down the temperatures. But I do believe that commissions have got a very important role to play, particularly that of establishing the facts.
Yes.
I have served in a number of commissions, not judicial commissions, but I've done a number of commissions in the hospital in Gauteng. At one stage, I did commissions in almost every hospital except Baragwanath. And when I looked at how those facts that we have put forward actually assisted in developing certain labor relations processes, I had found it quite a very useful process. And as I said, if you look at the Vihan Commission, you can criticize Vihan, the approach he adopted in a number of respects, but overall, it was a major success and a breakthrough in terms of changing our labor relations. So fundamentally, I would say what is important is the political will for those who are responsible to implement the recommendations of the commission that determines the value that the commission would add. But also we must remember that the commission in general are not that determine the finality. If I accuse you of wrongdoing, it can't be for the commission to then determine whether you are guilty or not. You still need to be given an opportunity. All what the commission will do is to say you did.
To need a mic here in the front for the DG. Making notes, there's also one here. And before I open it up also to the floor, JP, another point that you made was something that I found things that could have been sorted out by the courts themselves. Let's hear from you on such issues, issues on access. Are we really winning in terms of making sure that
across every corner of the country? And unfortunately, we're competing like everybody else on the budget. So we don't have a budget that would place us everywhere else. But what I have said and I have tried to implement is to make sure that any area where there are significant number of cases, we should be able to go there. As I speak to you, we have started going to Limpopo, and we're using the High Court there. I have offered to the practitioners in Mpumalanga to say it's just for them to shout and tell us. And remember, we've been using a manual system. So it's an impossibility to go through each and every file and say this matter comes from Mpumalanga. So we rely on the willingness of the litigants to come to us and say, we have a number of cases in Mpumalanga, could you come and hear them? Same with the Northwest. We have had some cases in Potchefstroom, I think. So yes, we will do our best, even with the limited number of judges that we have, to allocate judges to go to those particular areas. Sometimes we look at them in terms of the number of files, but at times we also look at them at the importance of the case and the number of employees involved. In that case, in fact, the Rustenburg case, we went to Rustenburg largely because there was a number, I think it was about 250. And we thought for those people to be transported from there to Johannesburg, it's a logistical nightmare. So we'd rather go there, yes. So we are committed. We have had an undertaking from, we're part of the judiciary, and the heads of court has offered that if we need any space as a labor court, we can always go and use the other court space. They're also struggling with space, by the way.
All right. Thank you for that, Judge President, because access is indeed important. Let's take it now to the floor. So we'll start by the corner there. Yes, sir. And then we'll come to you, DG.
Job that the commissioner or the commission can do. In this regard, I'm referring to, you'll remember the Seriti, you'll remember the Marikana one.
I cannot
Yeah.
hear.
In my view, in those instances.
If I can ask you to just project a bit so the JP can hear you.
Okay,
Yeah.
I'm saying I agree with the GP when he says commissions are in some instances, that's my qualification. In some instances, I mean, they are okay, and then he gave reference to the White Commission. Yeah. But at the same time, yes, I agree, but from my side, I feel like in instances where we have got other agencies that they can do the same job, so we should actually prefer those agencies. In this regard, the example will be, I'll give you an example of Marikana. I believe that in cases such as Marikana, the commission was not necessary. We needed just police, I mean, to do their job, and then those who are found guilty, I mean, get
All right.
through court processes. Because as a country that we are always complaining about the resources and all of that, I think, I mean, having a commission and then later have the police, I mean, to go, so it's just misuse of resources which we don't have.
Thank you very much.
My question, now I'm going to my question. My question is, I just want to hear the GP's stake, because I heard he spoke about the labor law being a specialized one, which I 100% agree. So what's your take, GP, on this pattern of having labor law cases going through the labor court, labor appeal court, and then taken to SCA? So what's your take on that one? Because
all right.
As a specialist court, I will expect that the LAC must be the last court of appeal. Otherwise, if there is a constitutional issue, it must go to the constitutional court. Thank you very much.
Thank you very much. Ladies and gentlemen, can I please ask we keep it down so we're able to also get some of those questions from the floor. Let's bring it to the DG right here in front. JP, I hope you're making a note of the questions.
No, thank you very much. Let me also not try and do the State of the Summit address. JP, I'm extremely fascinated by your speech, a moving speech indeed. You mentioned a number of very interesting points, but for me, the issue is about criticism of the judiciary. Very few experts from the judiciary take kind to criticism. They feel that you undermine the judiciary. We've seen even former chief justices taking it up to some people and saying, what are you doing when you undermine the judiciary? And for me, you've hit it on the nail. How do you get feedback from people that you serve other than in other forms as criticism? That's feedback. As to what you do about it, I think it would be up to you. But don't you think that you are swimming against the tide? You might be a lone voice among many who really don't take kind to this. But I must encourage you, and I see you coming across as somebody who's really prepared to transform the judiciary. And I wish you well. Thank you very much.
Thank you very much, DG. We can bring it now to this side. There was another hand I saw this side, my good sir, coming to you straight away.
Good morning, JP. Thank you very much for the insightful presentation. I just have one really question with two parts, and that is, you've just now alluded to the fact that there's really a scarcity of labor court judges. But in the face of that, what can the court do to accelerate the caseload? Because we know that you wait literally years or months for a case to be set down. That's the first point. And then the additional one is what can the Labour Court or then the Judge President of the Labour Court do to ensure that judgments are actually handed down timeously? I'm from the Eastern Cape, and we have some experience there where there's still from an acting judge, judgment outstanding for almost 2 years. And that affects the parties significantly. Thank you.
All right. Do we still have more questions from the floor? All right. I'm going to take one last hand, Judge, before you answer, and then we'll open it to the next round of hands. So there's a table there, in the middle there. Yes. And can I also just ask that just maybe a quick intro, name, surname, and where you're from, and then also just bring your mic closer so we can hear you. Thank you very much.
Thank you very much. My name is Mafu Rakometi, and I come from Umalusi. Yeah, no, JP, I need to appreciate your presentation as well, and maybe I repeat the words of the DG. They are well articulated. I don't want to spoil what he has said, but I fully agree with what the DG has said. JP, I'm worried about how cases are prioritized. You find with the case backlog that came as a result of COVID, cases that date as far back as 2017, 2016, thereabouts, that have not been heard by the court. And then we have some of the most recent cases that are high profile, that are prioritized by the courts. I would want to know what criteria the courts are using for them to fast track some cases, while there are other cases that would be pending for a very long time. I'm lost there to say, how are cases prioritized by our courts in South Africa? Thank you very much.
All right, thank you. JP, over to you.
Thank you very much. The first of the commissions, again, just to emphasize the point, commissions of inquiries are appointed to dig out the facts. They're not really determined. At the beginning, I was involved in land claims. And I'm sure some of you would know about the Makuleke land claim. It was one of the biggest land claims. Now, somehow the Department of Land Affairs then decided we use them is a different story. Cases taken from the court, the LAC, SCA, and the Constitution. LAC, SCA, and the Constitution. Just let me clarify the first point. Previously, cases with the system. The system is over-pressurized. Now, your body, the ELRC, was created for the purposes of dispute resolution. And it is for you to act. Those who were involved will tell you, they thought, in fact, the starting point is the CCMA. I think they said they were looking at 50,000 cases. When Sidumo came before the Constitutional Court, if you read that case, you'll see the judge is speaking about 500,000 cases that the CCMA has to deal with. So you can see that people prefer to use the courts than exhaust there are remedies in the bargaining council. I think we need a kind of putting our heads together as role players, the labor court, the CCMA, the bargaining councils, and everybody else, the unions, to say, how do we deal with this problem of all cases, almost invariably every other review doesn't just take 2 minutes. In the High Court, if you are doing an opposed motion, you can go in there with 55. You're done. 12 o'clock, you're done. You go into the labor court. We give judges only 3 review files in the unopposed motion. And then I think there's about 20 other 3 files unopposed, and that's where some people get frustrated. They fight with the judge and say, but my case was not opposed by the employer. Unfortunately, the law says, as the labor court is concerned, the criticism of the judiciary, well, there may be judges that may feel that they don't want to be criticized. But I think if you look at it, it also relates to the manner in which the criticisms get leveled. Some people do not respect judges. And it doesn't only relate to the judges. It relates to also the staff. If you are a consumer of a service and the staff tries to explain to you and you don't agree with the explanation, please don't insult that person. Please don't ill-treat that person. I mean, what I see sometimes when I walk around in the labor court, it breaks my heart. People literally insult people. And it's a culture that I think this country needs to revisit and look at. And it's not only in the labor court, even in your schools. I've got sisters that are teachers. And when I tell them when I was in the education sector at the university, I never had any student talk back to me in an insulting manner. But these days, you get all kinds of things. I think it's one of the issues that this society needs to address. But I can say to you, I sit in the governing body, the heads of court, of the judiciary. And repeatedly, our Chief Justice keep telling us, and we all keep saying to our judges, when you speak to people, remember, you've got to respect them. You've got to respect them. And I learned one lesson when I was in the States and I was working as a clerk of one of the judges as a volunteer. And this judge was doing a case of a doctor from Cuba. And the environment was quite negative. You know, this usual thing that because he's a foreigner, he can commit all these malpractices. And so when we get into the court, he didn't follow the traditional way of judge walking in, sit down, all rise and whatever. He looked at the back and he called one of the lawyers and said, Mr. So-and-so, you know what? Let me tell you, you better go back to your office and do fruitful work. I'm not going to hear your case until 2 o'clock. And that took me by surprise because I had already gone into South African courts where magistrates will be like, who are you? Why are you here? And whatnot, whatnot. And then I spoke to him and I said, but why do you do that? And he gave me a lesson that I never forget. He says, when an advocate comes before you or a lawyer comes before you, remember that he had engaged with the party and this person believed that they have a case. And when the lawyer says, no, you don't have a case, there's pressure put on the lawyer. And now think of it when the lawyer now comes before you as a judge. You now make matters worse. They come there nervous, and now if you start insulting and treating them badly, it's not good. But I can say to you, in the heads of court, we speak about. Similarly, if a judge ill-treats a person and undermines the dignity of a person, you should be able to come to me. And I should be able to sit down with the judge and say, Judge, but if you use these words, were they proper or not then? But to emphasize on criticism, I think I did say academics are key in as far as criticizing judges are concerned. of a judge, take it on appeal, and sometimes in the labor court I do get letters where judges are criticized, and I look at them and I say, when I meet with the judges at tea, I do mention that there is this criticism. We seem to be going this way. Should we not be aware of the... Or how do you get feedback? I think I've spoken to it. It can come in the form of an article. It can come in the form of appealing against the decision of the judge. Searching labor court or scarcity of the labor country. But again, a commission of inquiry has been appointed, led by Judge Moseneke, the former Deputy Chief Justice, with that commission. And personally, I would say it's one of those commissions that have moved with extreme speed. I was surprised that the second report has already gone out, and there's been an indication by Moseneke, and one of it relates to the whole issue of scarcity of judges. And I understand very soon we may get handing judgments timeously. Let me start off by really apologizing. It is a big problem in the labor court. I know other courts have got the same problem, but we've got the biggest problem. I am attending to it, and I'm seeking to find ways of dealing with this particular. One of the strategies I have developed is to ask the parties if they're willing that I can shift that case from that judge to another judge. The other strategy I have applied, who told us that he's got 5 researchers. In the labor court, up until now, we had only 3 researchers serving the labor court and the labor appeal court. Only recently did they, of what, 14, 15 judges? Sure. You add 3 judges or 6 judges of the labor appeal court, that takes you to close to 20 judges being served by that. So that's the one problem that one of the researchers and say, please do a note for the judge. Summarize what is this case all about, so that he can make reference to what files, these big files, not half empty, full all of them, 35. And then you say, I'm going to give a judge to look at this. You need what? A month to read that file. So those are some of the challenges that we do encounter. And in that regard, I've tried to use case management to try and resolve this case. I mean, I'll give you again an example of this case. When I saw the files and I asked the registrar, what's happening and when is this matter going to be enrolled? She said, Judge, I still have to find 2 weeks which is open. I said, I'll get case management. I got the lawyers together, and I said to them, you can't expect the judge to read 36 files. When we got into the case, it then came out to me that, in fact, there were 8 workers who were charged for misconduct. 4 of them had withdrawn, or no, 2 they have settled, 2 had withdrawn. So you were left with 4. And each of them were charged with separate misconduct. So each one of them must have had their own arch-lever file. So what about the other 4? Why do you need those other 4? So we're using case management as a way of dealing with the problem. So yes, indeed, I will say the issue of judgment is the biggest problem that we are faced with. Prioritizing cases, I'm not sure how that would happen, but I can only but say it's possibly because of the manual process that we are involved in. Some of you who may have been in the labor court, you would have seen every corridor, every passage that you turn, it's files both this side and that side. You can hardly walk into the registrar's office. You can hardly sit in the registrar's office because there are files and files, and so that is the biggest problem. So I'm not sure, and I hope prioritizing of cases here, we're not confusing urgent cases, because there are cases that are urgent, that would come quick. quicker and be processed forward. But also, there is a system that allows, in terms of the rules, to write to the judge president and say, please prioritize my case. I scrutinize those cases personally, very closely. If I find that it is a case that indeed deserves to be prioritized, I do prioritize it. Depending on the nature of the case, I will prioritize those cases. Cases of harassment, for example, those are cases for me that I would move the case forward. Because you can imagine if the victim wants to know the outcome, and you're now holding back and say you'll wait for the queue, what happens to that victim? But similarly, the person who's been accused also wants to know the outcome. He may be a manager, and now, as a manager, either you've suspended or he continues to manage. The confidence in the workplace gets dented. So that may be the reason for some of the cases that move forward. But otherwise, in as far as the allocation of cases are concerned, I've taken all that into my chamber, and I've got a judge who deals specifically with every file that is there. And those who come from KZN, you will notice that we've now pulled out all the files. Similarly, in Johannesburg, myself and the senior judge, we work on those particular files. Oh, I think I've addressed this. I think that's...
Yeah, that sums it up, JP. And we must thank you so much as well for your active participation in making sure that justice is served. I know we're well into our 30 minutes of the session, so I'm going to short and sharp, please. Yes, right there.
Thank you so much for accommodating me. Good morning, and thank you, Judge, for the presentation. Mine is just a quick one. In your presentation, you actually emphasized more on unfairness within the workplace and the discrimination. But what I want to indicate is the current trend that is taking place within the workplace on the issues of bullying, which then is a very subtle act which affect workers, especially the mental health. You have indicated that law is not static. But what I want to know is to say, because at the lower levels, I think there is that challenge of integrating the labor legislations with the constitution. Hence, people actually prefer to go to the labor court. What is it that actually the labor court is doing in terms of integrating or contextualizing the issues that are brought before the court in relation to bullying and the impact of bullying on mental health? Because we know that the majority of the workers becomes difficult for them, especially if they have to submit evidence on the basis of deal with. Thank you.
JP.
Thank you. Thank you very much. The issue of bullying, I must confess, I haven't really come across a case that directly deals. I guess it would be unfair to terminate on the basis of mental health. But mental health is a very complex process, as we all know. I'm not talking scientific. I'm just talking from anecdotal and from a personal observation. You know, in the workplace, when they speak, they are very aggressive. And there are people that are temperamental. I can tell you, I have already noted at the out what could be the problem. And I had a case study where when the manager finally spoke to this, and the question is, how do you deal with it? For me, no better solution than simply dialoguing with that person, sitting down and saying, what can we do? Not necessarily saying you can. As I say, I wouldn't want to comment too much on bullying, but I know in other countries, in America, for example, they have taken the issue of bullying quite seriously. They have
Come forward and hand over your gift, Judge President. Judge President, we're going to hand over a gift just as a token of our appreciation to you. The General. Break, which will be for about 10 minutes, just a short tea break, as well as a little comfort break so we can continue, because I see we might just be pressed for time. So let's go out for a quick break and then see.
Education Labor Relations Council Labor Law Seminar 2025, where transformation begins. When labor evolves, justice must lead. Landscape changes, leaders must rise. Join us from the 11th to 13th of August 2025 at Empress Palace in Johannesburg for the Education Labor Relations Council Labor Law Seminar, under the theme, Adapting to an Evolving Labor Landscape to Promote Social Justice. It's a strategic gathering of policymakers, union leaders, educators, and legal experts converge to chart the future of work, rights, and equity. Education Labor Relations Council Labor Law Seminar 2025, where transformation begins. When labor evolves, justice must lead.
About dispute resolution, and I'm told this is the 3rd edition. And LexisNexis will be in a better position to tell you how you get to access the book. But these are some of the great minds that we have in our midst this morning to come and share their insights around their fields of expertise. Mr. Patelia, over to you.
Sorry, I need my presentation up. If there, please. Hello, hello. Can you hear me? You can't hear me. All right.
Let me just, yeah.
I need that on. Right, good morning. Thank you very much for having me. It's an absolute pleasure to be with you. And it's one of the things that we can be quite proud of, where we have bargaining councils like the Education Labor Relations Council that takes the education and development of labor law knowledge so seriously. And its contribution is not only within the sector, but beyond as well, if I look at the program. So it's a real privilege to have been invited here to speak. And so thank you very much to the Secretary and the Chairperson of the LRC. I rest on the protocols before, but just to acknowledge the DG, of course, and leadership from the unions that are here and other parties as well. I chose a topic that I think is not only currently top of mind when we look at the amendments that are being proposed to our labor laws, but in particular zoning in on conflict management and disciplinary processes. It's not my intention to go through those amendments with the required detail. The eminent speaker next, Teresa, would be taking you through the Code of Good Practice, but I'll be touching on it. But the choice of the topic is one perhaps of, well, firstly, it's opportune given that it is topical, but it's something that as a dispute resolution practitioner, after many years of practicing, one has to often consider what is the best way to resolve conflict. And we profess to know our labor laws, as was correctly stated by the JP, is world class. It has something that we can be proud of in the sense that it includes an internal obligation to fix fights. And even when we are in a marital relationship or any other type of relationship, there's no legal obligation to fix our own fights. There's maybe a moral one that we require to do so. But labor law places that obligation, and it comes with its pros and cons. But also, when we have disputes, as we all know, the primary focus is on the parties speaking. And that ability to engage and communicate is quite critical in our labor dispute resolution system. And the JP is quite right in the envisaging our dispute resolution system. The type of pressure that we are currently experiencing at an arbitration level or at the labor court and labor appeal court level was never envisaged. The idea being, of course, that the parties could, of course, resolve a lot of their disputes between themselves and much sooner. But that takes away from human nature. And one of the key components that I am focusing on is really the human experience in conflict management. There's a lot of technical debates that are taking place in terms of the proposed amendments and what is required from amendments. And those are useful ones, and there are people that are better equipped to talk about them. But what I do know is that the more technical we become and the more procedural that we are, and the more that we utilize courts in a system and in a world where courts are overutilized and are failing, then we need to be careful. It's in our civil justice system that the now appointed Deputy Chief Justice, who had initiated the project in the Gauteng courts in our civil justice system, has made mandatory mediation. And the reason is the civil court system is so clogged that if you want a date in court in our civil justice system in the Gauteng courts, you're probably going to get a date in 2031. And we complain about the problems we have in labor. I'm not saying one is better than the other. The challenge is that in an under-budgeted, under-resourced justice system where you have access to justice and you rely on court systems to deal with problems, it's not only proven to not work exclusively in South Africa, but this is a worldwide phenomenon. And so we need to be very careful when we take one approach over the other. I don't necessarily have the answer, and I'm warning you in advance. What I do know is that there are many questions as to what would be appropriate from a dispute resolution system. And my focus is internally, because the beauty of our labor law is really to focus internally for the parties to fix their own fights. Yes, there's a formalization of processes, and in some instances there are collective agreements that support it, which have become binding far more than any amendment that would then contribute to a new way of dealing with disputes. But internal dispute resolution is a critical component of our labor laws. And that is the focus not only of this talk, but potentially some of the amendments outside of those that will be for the CCMA and the labor courts. And so I said one is, of course, it's very topical. The other, I have my eldest daughter who's just started her journey of work this year. She's a vet nurse. None of them followed in their father's footsteps, obviously. The mother's a psychologist and the father's a lawyer, so they, of course, went into completely different professions. But she comes with the most wonderful stories home every day. And I'm enthralled by them because they deal with her relationship with her patients, which are these animals. And sometimes I say, I wish I was you. I don't have to deal with the human beings around me. because there's so much that you can gain from that. But our paths crossed the other day from our expertise, because in her work life, as a newly working vet nurse, she obviously is working in a work structure that has management, that has a supervisor, blah, blah, blah. It's a small business. It is not by any means the public sector. But she complained about how she's been managed by her supervisor, and the supervisor called her into the room and told her that she's given her a warning, and this is quite devastating for my child, who's a high achiever. I'm like, what did you do? That was my first response. Just nothing. She blamed me for something that she was trying to cover up and gave me a warning. And so the labor lawyer in me kicked in, and the father. I'm here to your defense. Can I write them a letter? And I'm going for them. And her answer was, don't you get involved. Aside from me being her father, the fear of what? Reprisal internally. The fear of losing her career. The fear of many things that we know as lawyers and technical people, we can find answers to, and there's dispute resolution processes that deal with that. But for her, it was very personal, it was very emotional. She is not thinking technically as I am thinking. I'm in the space of cognitive thinking where we are here today, and you'll be for the next few days. But the human experience of that really got to me. It was quite personal. And my question then is that in knowing this, when we look at our labor laws, which provide us with processes internally that rest on fairness, and effectively we have a formalization of conflict management processes that really depend on this disciplinary process and grievance processes. And when we talk about amending them so there's a greater degree of flexibility, and that there is a greater discretion given to employers to potentially, mold the processes, still preserve fairness, but mold the processes to their circumstances and their businesses. The obvious fear would be, can I trust the employer to do the right thing? And it's a fear that is quite real for an employee. And it's a fear that is quite real for unions as well, where there's a greater discretion given around processes where I cannot pin my finger on it or define what it is, that from a human perspective, I've got to trust the employer. At least with the disciplinary process that has been in our system for many years, there's a formalization of the process. I know what to do, X, Y, Z, etc., etc. And so we have this, this fear, and it's really as a consequence of a lack of trust. But importantly, and I was taking copious notes when the JP was speaking, because I look for certain gems that help me as well in terms of my own thinking. And the one aspect that he touched on, which I believe I align with as well in terms of my own thinking on this topic, is that aside from trust and relationship that is required in workplaces for any policy, procedure, or law to work, the other is a common set of values. So part of my presentation, which I may not get through all of it, but you'll have it available, is, we'll quote the Constitution. Our value base should be based on our Constitution and the rights enshrined in that Constitution. But it does require us in the practice of what we do from an employment perspective, and I know this sounds very idealistic, is to have a common set of values. So that any policy, process, or regulation that we have internally could find favor on both sides in terms of its acceptance. And it is that value base that is of concern to me and to others as to what's exactly happening from a behavior and conduct and value perspective. Because discipline and grievances should not be limited to these archaic types of processes that we have. I've chaired many, many processes over a period of time, and as a consequence, have realized that they are quite alien to what we'd expect of a process or a mechanism in which we'd want to deal with conflict, especially in personal relationships. At the heart of any conflict management is the ability to communicate and engage carefully, is to be conscious of the relationship and the opportunities there are to nurture the relationship. It should not be a game of chance or chess or war, often in which disciplinary processes and at times grievance processes are managed, where it's quite antagonistic, it's quite procedural. But those are not our only options. Part of what I've been doing from a practice perspective is, of course, working with companies, but also as a dispute resolution practitioner, introducing other forms of dispute resolution within workplaces, which sometimes can be very scary because it's something new. It's difficult to manage, it's difficult to evaluate. But I am very conscious of the fact that whatever we do should meet the test of fairness that is prescribed in the Labor Relations Act. Procedural and substantive fairness, the employer has the onus to provide that, and certainly employees have the right to test that before a commission or bargaining council. So where there's been very interesting work that's been developed is around workplace mediation. As an example, and I'll be touching on that, and it's a large part of what I believe is required from the evolution of thinking in dispute resolution systems within workplaces, whether they're your systems or they could be the veterinary practice where my daughter works, and there would be an opportunity to look at the possibility of talking to each other with a mindset of finding resolution rather than attributing blame, because then blame could be saying, okay, I've done my job, I've held you accountable. Because the fundamental question around workplace mediation as well, just as whether it is applicable only to grievances, yes, it has a primary role in managing grievances within workplaces, but why not rights-based disputes? Because as much as we'd say rights-based disputes cannot be negotiated, and I understand the legal principle, why then is the first dispute resolution step at a bargaining council of the CCMA an opportunity to talk and find a negotiated settlement, even on even on rights-based matters? Why not do it earlier? Why can't workplaces themselves have the opportunities to mediate? And it is these things that we need to start discussing. I know there are many fears and there are many concerns and there's a potential for abuse. One of them, of course, is how can a dispute resolver who's mediating an internal rights-based issue ensure that they're not forcing an employee out by utilizing mediation? The other is, of course, the introduction of the informal procedures, what we understand to be informal or more flexible procedures. And informality of discipline is sometimes a misnomer in the way we use it, because the idea that there being two layers of process, informal and formal, even exists within our own systems. This is not new, okay? Of course, our courts have recognized, and I know some of us can debate and evaluate this, is that the courts have for a long time recognized, and at least this judgment, which is often cited, the Avril Elizabeth Holmes judgment from 2006, has recognized that employers and management should not be a replication of our criminal justice system. We don't have a prosecutor and a judge prosecuting a wrongdoer. And often the disciplinary processes that we experience is so close to a criminal system that it cannot be what was envisaged in terms of our Labor Relations Act. This is still an employment relationship. It requires the employer and employee to engage and use the systems to advance the relationship where possible and terminate on the basis of fairness where it is required. And so this, of course, has been used and sometimes abused as a judgment in different situations to encourage a greater degree of flexibility in the way disciplinary processes are utilized. One matter that became quite controversial was the Bimau versus SABC matter. I was one of the chairpersons burdened with this matter. And I can tell you the unions still are not very happy with all the chairpersons that dealt with those matters. Maybe time has, softened them. But in this particular matter, over 100 employees were accused of committing medical aid fraud at the SABC. Now, it was quite sophisticated. I was amazed. It included doctors and medical aid claims, and everyone was making a cut. And eventually it became like, the sort of, I don't know what's it called, a pyramid scheme, or like you sell in Tupperware. You recruit someone else and everyone's making a commission in the process. And it became quite sophisticated. The problem that the SABC had, of course, in this matter was, how do you take over 100 people through formal inquiries? You can't have a collective disciplinary inquiry. And so they chose an approach of dealing with the disciplinary process on paper. Highly controversial. Highly controversial. So it was, employees were still given notice. They were allowed representation. The employer presented their full case in documentation with supporting evidence, and the employees were allowed an opportunity to respond in writing with whatever supporting evidence that they had. There was no restriction, and as chairpersons, we were asked to consider that. And secondly, as well, where required, we could call for evidence to be heard. Most instances, the evidence was common. I mean, it's factual information. You've got a medical aid report, you've got records from the doctor, you've got an investigative report. And this matter was, of course, in a number of instances, employees were dismissed as a consequence. And this matter, of course, went before the Labour Court. And the peculiarity of the circumstances made the court recognize the importance of flexibility in processes, but not taking away the fundamental rights of natural justice. And this process, which I'm simplifying, of course, was found to be procedurally fair, effectively. There was no judgment, irrespective in terms of the focus of moving away from what the disciplinary code and procedure had said. But it is not the rule, it is the exception. This great degree of flexibility that is provided in situations where there is formalized processes should be the exception. Now, just to go to the draft code of good practice, there cannot be anything controversial with the key principles. And I've said that Teresa would be going through this in more detail. But it places a premium on responsibility on both parties, employers and employees. And this is fundamental because from a rights perspective, we are very focused on the rights we have, whether we are employers or employees. And that can be defined as power and abused as a consequence of our focus on that power. And that's the reason why we have so much difficulties in a lot of these disputes, where disciplinary processes, and we've seen that in the public sector as well, have been used as a power, something to attack the other side, rather than as a means to deal with something gone wrong in a relationship. We've moved away from the human focus. But also on the employee's side, there's a lot to be said in terms of how employees react to discipline, how they focus on their rights rather than responsibilities as well. And this is nothing new in what has been said here, is that there is a requirement for processes to be expeditious. It must be accessible. Why do we want internal processes to be so formalized? I'm not saying you, that the courts also say, well, hold on, that should not be that. And where the courts are striving to ensure that there's greater access. If I hear the JP, his focus was really around the human experience when they entered the courtroom. And it is not the most pleasant place to be. I know very early on in my career, after doing articles, having experienced what was called the Central Divorce Court. Does anyone know the Central Divorce Court? It's based in Newtown, in what is now the trendy Newtown in Johannesburg. And what was unique about the Central Divorce Court, which is now called our family courts, is that it would only deal with black divorces, black people's divorces. As a privilege to them, and as a lawyer going their experience in that, I was astounded that you could get a divorce literally in 2 minutes. Maybe that's the reason I got married early. No, it's my wife's not here, so I have the privilege of talking about like this. So I have a bit of power allow me to do that. And when we recognize that court systems can really abuse the rights of parties and the systems are so unnatural that the judge in that court actually spent more time shouting at the legal practitioner because her skirt was just slightly above the knee, and the next legal practitioner had a blue shirt on instead of a white shirt. Fortunately, we move in past that. But some of our legal systems and traditions are still entrenched. It is not human. And so we have certain fundamentals that is around the code of good practice that are requiring us to be a bit more sophisticated in the way we deal with disciplinary systems. It cannot be a one-size-fits-all. And this is an important consideration because what we recognize is that any conflict management system or dispute resolution system needs to be appropriate to what is before us. Now, but this does require a level of sophistication of a manager that they can exercise their discretion appropriately. Because every manager that I have trained is really looking for a checkbox and a textbook on how to approach discipline. It's not in their DNA or in their nature to deal with discipline creatively. So this is a risk, but I can see it as someone who has practice in dispute resolution, that the opportunity for applying what is appropriate makes sense. It's not saying that we should have informality and a lack of process in all instances, but we should consider the nature of the employer. We should consider the circumstances that prevail. And like I've said, I'm not going to go through the detail of this. The essence of fair process, and I'm just going to skip ahead, still rests on the rules of natural justice. The right to be heard can never be removed. The quality of that right to be heard can never be taken away. The method of the right to be heard can vary. Our courts recognize that. Not every matter is dealt with on evidence. We know that. You draft court papers and there are motion proceedings. There's different ways to get to a point of an outcome. Our condonation applications as well and rescission applications are done on paper. And I'm not saying they're perfect. In fact, we've given ourselves a greater degree of flexibility in those written applications that even if an applicant does not provide it in the form of an affidavit, I as a commissioner needs to exercise a wider discretion in recognizing the words and meaning in that document rather than its form. And that's how courts have told us. So the right to be heard can vary in form and still maintain procedural fairness. The second one is a bit more challenging, the objective decision maker. And this sometimes creates a lot of fear and anxiety. Because how can someone who's inherently biased and wanting to do the wrong thing as part of their business strategy be fair? And I accept that. But that's not every business. If you look at the statistics and the data from the CCMA, a vast majority of employers are successful in their cases at arbitration. That may mean that various things. I know when I started in 1997 at the CCMA, in the first few years, employees would win cases regularly, 60 to 70%. But employers, especially big employers, have a way of changing their internal processes, developing their managers, and this is what they should be doing, aside from cut and paste processes. Ultimately, fairness is the test. And the aspect around what would be the consequences of us, well, perhaps let me just rephrase that. One of the arguments that was presented, I don't know about which side in this debate that's taking place on the amendments, and it's an interesting one, is that our dispute resolution system is very complex. At the same time should be accessible. We have an internal dispute resolution system which must then have fair process and substantively must be fair. It can be tested at the CCMA or bargaining council, however. The however is that from a substantive fairness perspective, it is a hearing de novo. Now, the proponents for the amendments argue it doesn't matter how I get to the decision. Of course, the procedural fairness must be intrinsically in place. But if my decision is fair, it will, or unfair, it will be ultimately evaluated at a de novo hearing, which is the responsibility of the CCMA and bargaining councils. But inherently, I think that's part of the problem. Irrespective of what you do internally, the bargaining council and the CCMA has the ability to listen and an unfettered ability to receive disputes, have a conciliation, schedule it, have an arbitration, schedule it, and it's a complete de novo hearing. That means it doesn't really matter what happens internally. Any employee, whether they have a good or bad case, will have a right to conciliation and arbitration. And that's the beauty of our labor system, but what it does do is it's estimated that the CCMA would be dealing with about 250,000 cases in this financial year. 250,000 cases in this financial year. I'm sure the CCMA would have better data and statistics. The other component is managers don't know how to manage. And this has been my experience when managers who know their operational work, and then they're told to discipline, really freak out. And they can't balance what is the managerial prerogative and what they should be doing from an operational perspective and from a relationship perspective. This ability to be, I'm not saying all managers, it's just, I'm saying generally what we find. And the understanding that they have a right to manage and what's the limitation of that is important to consider. Because if managers are responsible to manage and manage discipline, they need to understand what to do. So the limitations that may exist to this managerial prerogative as we take the journeys forward is an important consideration. Like I said, the fear is that it can be abused. Sorry, I've skipped through some of those slides in the interest of time, but none of those fundamentals would change. Procedural and substantive fairness, who has the onus, who would face the risk, what is the implications of discipline in terms of it being progressive and corrective in nature. None of those fundamentals change, essentially. What we need to consider from a disciplinary perspective is, of course, we've got to wait for NEDLAC to have a decision as to what the amendments would be. But my point is that I never was one to argue for a change on policy to fix problems, because often we change policy, but we don't change the practices. The practices are bad whether there is a change in policy or not. We have had a system that allows us some degree of flexibility in the way we manage discipline from an employer perspective. I don't see a fundamental change from what Avril Elizabeth Holmes has said. Maybe we're going to see it in practice. But the will and willingness of the parties to abide by policy and procedure is the more challenging component. The other aspect that I'm going to just touch on, I'm not sure how much time I have. 5 minutes. Okay, cool. Is on workplace mediation. Now, Wits University, as an example, trained a number of internal people to be mediators. You know, some of the systems within universities are very archaic. You have some systems that are dependent as well, given the nature of the communities, on ombuds. There's different methodologies that universities have been using. But from a workplace perspective, Wits University introduced workplace mediation. They got internal people, staff, to be trained as mediators. And the idea being that those mediators form a professional body within an existing community. It's not an external mediator that you appoint in from the outside. And the system is managed by an independent office, and that office regularly manages the continuous professional development and the practice of these mediators. Now, why this is so interesting from a South African context, of course, is that it goes beyond just providing discipline and grievance processes. It provides what I believe to be the most human human way of dealing with dispute resolution and conflict management. Of course, I'm a very strong proponent for mediation. So I would say this. So workplace mediation rests on the same fundamentals of any mediation. It requires highly skilled mediators. In fact, those mediators, I'm using this as an example, were trained in the highest level of mediation from a commercial mediation perspective. They've received accreditation that's of the highest standing. They need to meet this criteria regularly. There's an office that is established to case manage. There's an office that's established to administer the type of mediation, ensure that there's no backlash, etc. And they deal with a range of issues, from harassment, bullying, discrimination issues. As far as I know, they've not dealt with rights-based issues. And the way the process works is very simple. The parties themselves, if there's a grievance, can select from the internal panel of mediators, or they'll be appointed by a transformation office who controls this. And it's a very encouraging and interesting idea. The mediator would meet with the parties firstly as a pre-meeting and understand what the dynamics are in this particular grievance or issue, and then build a process with the parties. They're also educated on the process. They're told about the principles. They're made to enter into a document that they'll abide by the rules of mediation for this workplace mediation. In the mediation process, like you'd be familiar with, there's an opening process. There's a problem identification process. There's options that are generated. They select options. And then finally, there's an implementation of an outcome and which will be monitored and reviewed. The difference in this mediation is, I'm going to just touch on two, is firstly, most of the mediation takes place with the parties jointly being present, both sides. Unlike the type of mediation that we used to, where there's a lot of shuttle diplomacy between the parties, the fundamental aspect of workplace mediation is still protecting the job, restoring the relationship, and finding solutions with the parties in the room. And that brings about a very crucial change in the dynamic. The parties are sitting, facing each other, talking to each other, and engaging and listening to difficult things. But the mediator is managing those conversations very carefully. If needs be, there'll be separate sessions between the parties. The second, if you've been through an RBO process or an institutional relationship building process, the parties are, as these individual grievants, are made to focus on what they've done to contribute to the relationship breakdown and what the other party has done. And that's an integral component around problem identification, where the parties are given specific tasks. What have I done wrong? What have you done? And that focus changes the dynamic in workplace mediation. The issues are then clustered and understood by the mediator, And then the parties move towards a constructive methodology of building solutions. Very formalized way of mediating, but a very interesting one that produces some interesting results as a consequence. Now, to have this, and this will just be my last slide, Program Manager, is that it's essential for the very principles of mediation to still apply. And herein lies the risk. I was just dealing with a mediation recently, and I've taken to the idea of dealing with grievance matters in a hybrid form. It's not always liked by employee representatives. I'm told I'll be biased. So if there's a requirement for investigation or there's a requirement where I'm appointed to chair grievance, I'd ask for my terms of reference to also include the possibility of mediating. And yes, they agree, which means that I need to seek and look for an opportunity when the parties can engage in dialogue for a solution. But the risk is, of course, which I found in the last few months, having tried to mediate a workplace grievance, that I had a very antagonistic employee, okay? Antagonistic to anyone and anything. We'd agree, this will be the rules for the game. I'll wait literally 5 hours and I'll get 10 pages sent to me of why I am so abusive to her, and why I'm wrong, and why I'm biased, and why I'm harassing her, and why I am, et cetera, et cetera. And over the last 4 months, probably the judge president talked about 32 lever arch files. I'm pretty close to that, just by correspondence. And herein lies the risk of moving away from, moving to something that is hybrid and that can produce different results. Is that the parties themselves can abuse the process and abuse the mediator. Ultimately, what happened in this matter, I drafted various rulings and judgments, but on the very last point, just before I had to travel, and I was thinking I'm going to take away homework with me, the parties settled. The employee's form of negotiations was to start at 12 months and stick to 12 months if she had to leave. When she was engaged again, it went to 24 months. So she negotiated up. And ultimately, they reached a settlement. I'm going to pause there. But what I say in context is that for us to really focus on what is required in internal dispute resolution, we should not rest comfortably on the existing processes that are there. The uncomfortable truth is that we need to be creating change and momentum. And I think it was the JP's message as well. Stagnation is death. And so when there's a need for transformation in disciplinary systems, that potential should be utilized. Thank you very much.
I'm going to ask you to grab a seat. Sure. So, all right, thank you so much for that, Mr. Patelia, for that comprehensive overview. Would like to now call upon Dr. Bono, who's the chair for the Elrc, to give us his presentation on the impact of constitutional law on evidence rules in labor matters.
Allowing for a more flexible and pragmatic approach to dispute resolution. Now, the next question is then, how do we as arbitrators manage evidence in labor matters? And unlike civil and criminal courts, proceedings at the CCMA and in bargaining councils are less formal. Commissioners are not bound by strict rules of evidence, but must still apply the principles of natural justice and fairness and procedural fairness. And as I indicated before, commissioners may even admit hearsay evidence, although generally it would be inadmissible, provided it is relevant and fair to do so. Just a few lessons before I deal with the judgment that I'm going to spend some time on. I thought it's important just to move from a premise that we all know, and the JP also mentioned Sidumo. We know that our South African courts have shaped how evidence is used in labor matters, and one of the landmark cases is the Sedumo judgment, which reminded commissioners that commissioners must use their discretion reasonably, but not mechanically. But not mechanically apply strict legal rules. Therefore, commissioners have a wide discretion provided their decisions are reasonable. The other case that I thought I'll just touch on is the Kumalo judgment, NUMSA on behalf of Kumalo, where the court confirmed that the CCMA must ensure that even hearsay evidence is tested for reliability and fairness. Versus CCMA, which is a 2008 judgment, where it was emphasized that the CCMA is not a court, and equally are bargaining councils. What is expected of these tribunals is that for commissioners must apply their minds carefully to the evidence that is before them. Avril Elizabeth Home, for the mentally handicapped, I think the case was covered. Fairness in how dismissals are effected. What these 4 judgments tell us, they collect how South African courts consistently champion procedural fairness in hearings and as an essential safeguard for employers' rights and an important check on how the Constitution has impacted how we deal with matters at the CCMA and about. So this was a rescission application brought by Mr. Motulwe, and his complaint was that despite bringing a cross review before the Labour Court challenging his facts in this judgment, the 2 gentlemen, Mr. Motulwe and Mr. Nkambule, were employed as transport inspectors by the incident that took place on the 15th of May 2013. And you will see that this is a 2013 matter, it's still not complete, and we're sitting in 2025. They were charged with corruption for soliciting a bribe in exchange for not a million start. They were summoned to a disciplinary hearing, and they were found guilty and were dismissed. So they referred the matter to the GPSS. Corruption, but they were not insubordinate. And the arbitrator found that their dismissal was procedurally fair, but substantively unfair, and therefore, instead of a dismissal, and so the employer took the matter on review. But the 2 gentlemen, Motulwe and his colleague, also and so the employer challenged the sanction, and this is important and it's going to become apparent in the next few slides. So the employer challenged the sanction and Motulwe and them challenged the finding. But the main review was that of the employer, and the review by Motulwe and his colleague was a cross review. In its reasoning, the Labour Court indicated that if it was to find that the award was reviewable, there would be no need to consider the cross review. So if we find that the award cannot stand the test of time, we set it aside, and therefore there is no need to deal with the cross review. Since it held that the arbitrator's award was reviewable, and it did what it thought so it naturally did not consider the cross review. The Labour Court concluded that the arbitrator committed a reviewable irregularity and set the award aside. It also did not deem it wise to remit the matter back to the GPSSPC, and they decided that the Labour Court decided that it would substitute the award with a finding that the dismissal of the employees was procedurally and substantively fair, which meant that it was the end of the road for Motulwe. What the Labour Court did not deal with, and we will see that years later the Constitutional Court deals with this issue, was that they had dealt with the main review, which dealt with sanction, and concluded that the award had to be set aside, but in them replacing the award and finding the dismissal to be substantively fair and procedurally fair, naturally, they had encroached on the cross-review, which dealt with penalty. Obviously, Motulu and Nkambule, the two gentlemen, were not happy, and so they appealed. Leave to appeal was refused. Those who are involved in these processes would know how long it takes. So they petitioned C. Their petition was declined. And so Motulu then brought an application for leave to appeal directly to the Constitutional Court. So the grounds upon which Motulu and his colleague just gave up shame. So Motulu pursued the thing alone. The grounds upon which he relied on included the complaint that the Labour Court committed an irregularity in not considering his cross-review. He pointed out that there were two reviews before the Labour Court. The one that was on the finding, which was the cross-review, and the main review, which was that of the employer, which dealt with the sanction. And the Labour Court could have only addressed the review to the sanction imposed couldn't have addressed the issue of sanction without first dealing with the finding. And it sounds logical, but that's how it happened. The Department of Public Works opposed the application for leave to appeal. It argued that the review was successful. Interesting enough, the Constitutional Court initially refused the application for leave to appeal on the basis that it did not enjoy reasonable prospects of success. So Motulu was not happy, and Motulu then filed an application for rescission against the refusal to grant him leave that he had launched. He's a very persistent gentleman. Motulu persisted with his original complaint that the Labour Court had erred in not considering and adjudicating his cross-review. The application was refused on the basis that no case has been made for rescission. This is a second decision by the Constitutional Court. Motulu did not give up. So Motulu went back to the Constitutional Court and asked that the Constitutional Court interfere with its own decisions, which is the earlier orders, on the basis that such was inconsistent with the Constitution. And I'm going to go back to those two rights that I spoke about. And he further argued that the Constitutional Court had to correct the injustice that he had suffered. He argued that sections 172(1) of the Constitution dispenses with the requirement of exceptional circumstances in the interest of justice. I spoke earlier about the interest of justice. If the impugnate order is inconsistent with the Constitution. Motulu persisted in his argument that the Labour Court's failure to consider his cross-review constituted a dispute that can be resolved by the application of law in terms of Section 34. Remember what I said earlier. He said the Labour Court's failure to adjudicate the cross-review renders its orders inconsistent with the Constitution. So he said, and he therefore requested that the court set aside its own orders because they were inconsistent with the Constitution. So this is the third time now. The Constitutional Court, in its analysis, indicated that the matter related to the application of the Labor Relations Act, legislation, enacted to give effect to Section 23 of the Constitution. So on the third time, in considering the request to intervene, the starting point in considering the third application, the Constitutional Court says, let's go back to basics. Let's go look at Section 23 of the Constitution and what its provisions are. In light of this court's decision in Nehau versus UCT, the Constitutional Court said such a matter raises a constitutional issue. This matter also relates to Motulu's Section 34 right to have any dispute that can be resolved by the application of law decided in a fair public hearing. So there was an issue of fairness here that the Constitutional Court had to deal with. So applying for the third time to the Constitutional Court, Mr. Motulu contended that the Constitutional Court was incorrect in refusing leave to appeal and in refusing the rescission of the decision to refuse the leave to appeal. The challenge that Motulu faced was that the Constitutional Court had already pronounced on the matter, and that gave rise to the whole issue of res judicata, which means that a matter has been adjudicated by a competent court and cannot be revisited by the same parties. However, in a matter between Molaudzi versus the state, and this is a criminal court case, the Constitutional Court had already deliberated extensively on the principle of res judicata and had decided in the Molaudzi case that the exception to the principle that the rule ought not to be applied with absolute rigidity. So already the principle of being flexible had already been applied. And if you look at Mukadam versus Pioneer Foods, where the Constitutional Court had said the lodestar is the interest of justice. Is it in the interest of justice that we intervene in this matter? So the Constitutional Court noted that the Labour Court review, the Constitutional Court noted that the Labour Court reviewed the award and then replaced it with its own decision, which spoke to both finding of guilt and sanction. And that was the challenge with the Labour Court's approach. The Labour Court, by replacing the decision of the commissioner, encroached on the finding, which was the cross-review, but said they are not entertaining the cross-review. So the Labour Court's order, which implicitly upheld the finding of guilt, did so in respect of an issue it did not adjudicate, because they had refused to adjudicate the cross-review. Its approach, together with its order, was highly irregular. The error had the result of precluding it from adjudicating a justifiable dispute that was properly before it and no one which it was obliged to adjudicate. So the Constitutional Court rightly concluded that Motulu's review simply did not enjoy the attention of the Labour Court on the account of this approach, which it found was grossly irregular, unfair, and contrary to the principles of natural justice. So that did not mean that the Constitutional Court still did not have to answer the question of res judicata. And the court noted that there's the possibility of a rescission based on the interests of justice, which is informed by the jurisprudence on res judicata. And they cited the Kamtuze matter, which I'm not going to deal with. But in that matter, before the Constitutional Court, the question then was whether Motulu's application meets the standard of interests of justice, and whether indeed there were exceptional circumstances for it to depart. And therefore, question that the court had to answer was, is the flawed manner in which the Labour Court dealt with his cross-review truly exceptional? And the court's answer in this regard was an emphatic yes. So the order that the court gave was that the Motule's cross-review application in respect of the finding of guilt be referred back to the Labour Court for determination by another judge. So Motule, 12 years later, is back at square one. So this judgment, I think, came out at the end of May, and Motule was fired in 2013. If the Labour Court upholds the cross-review and sets aside the arbitrator's finding of guilt, the Labour Court's order in the review application in respect of sanctions shall fall away. If the Labour Court dismisses the cross-review, then the Labour Court's order in review of application shall stand. The fight goes on. In conclusion, my view is that at the heart, or at its heart, the use of evidence in labor law is all about balancing flexibility with fairness. The goal is not legal technicality. And that's why I say it's quite disheartening when right at the bottom, at disciplinary hearings, you find that disciplinary hearings are being turned to court processes. And arbitrations are, even worse. It is so, these processes, as I've mentioned them, are there to uncover the truth and reach a just outcome. Whether you're an employer or an employee, your case will be strongest if your evidence is clear, relevant, and reliable. And these are principles that ensure that everyone enjoys the right to fair labor practices, as enshrined in our Constitution and in Section 23 thereof. Thank you.
For that, Chair. If I may ask you to please have a seat as well in preparation for our engagement session. All right. Okay, so we continue now. I'd like to invite now Ms. T. Achada, who's from Solomon Holmes Attorneys, and she's going to give us a presentation on the draft code of practice on dismissal. Round of applause.
Yes, yeah.
All right, so now so it's just...
Yeah. Okay, good afternoon, everybody. Ladies and gentlemen, esteemed guests, Director General. A big thank you to the General Secretary of the Elrc and Advocate Bono, I'm not sure where he is at the moment, for the opportunity to speak at today's seminar. It's an absolute privilege. Draft Code of Good Practice on Dismissal, and the purpose of this presentation is to highlight the difference between the current code or the old code and the new draft code. Now, on the 22nd of January this year, the Minister of Employment and Labour published the draft code of good practice on dismissal, and I'll be referring to it as the draft code. The last formal revision of the current code of good practice was made through amendments in 1996 and 2002. Since then, there has been no published update replacing the current code. Now, what is the Code of Good Practice on Dismissal? As you know, it's contained in Schedule 8 of the LRA, and it deals with key aspects of dismissals for reasons related to conduct and capacity. So the code was really introduced to supplement the LRA and to include factors and guidelines which parties would consider when determining the fairness of a dismissal. It provides very practical, easy to understand, even for lay people, guidelines for employers, employees, trade unions, and other stakeholders on how to give effect to their obligations in terms of the LRA in relation to dismissals for misconduct and incapacity, whether it arises from performance, ill health, or injury. Now, what are the key changes introduced in the draft Code of Good Practice? The draft code does not make drastic changes to the current code, but there are noticeable relaxations to process, to considering the nature and the size of the employer's business. There is greater flexibility, and it enforces the decriminalized approach to the disciplinary process. The principles of procedural and substantive fairness have remained unchanged. The draft code also incorporates dismissals for operational requirements, which, as you know, was contained in a separate Code of Good Practice dealing with operational requirements. The draft code offers clearer guidelines for dismissal, and it appears to be more user-friendly. An attempted departure from formalistic procedures when dismissing employees. Obviously, formalistic procedures are time-consuming, they're costly, and the draft code appears to simplify the processes and provide flexibility. Provisions relating to probation have been slightly relaxed to make it simpler for employers to terminate employment during the probationary period. Now, one of the big changes in the draft code is the introduction or the specific reference to small business. It isn't really relevant for our purposes, and I'm just going to touch on 2 points here. The code recognizes the need for flexible, simplified, or informal procedures when dismissing employees in a small business. So the decision makers, such as arbitrators, would now be obliged to consider the size and nature of the employer when assessing procedural fairness. One of the big criticisms in terms of the draft code is that small businesses isn't defined. And the question is, do arbitrators have to look at the annual threshold of the business or how many employees the business in fact employs? Now, when is a dismissal considered fair? A dismissal is fair if it is for a fair reason and in accordance with a fair procedure. The LRA, as we all know, lists 3 main grounds on which a dismissal may be considered fair. Number 1, your misconduct, your theft, your fraud, abuse of leave. Number 2, incapacity. This includes poor work performance, your ill health, your injury, and then your operational requirements, for example, your retrenchments due to restructuring. So the code also deals with when is a dismissal automatically unfair, and I think a dismissal is automatically unfair if the reasons for the dismissal infringes on the rights of employees and trade unions, and if the reason for the dismissal is one of those listed in Section 187 of the LRA, for example, related to pregnancy, unfair discrimination, or participation in a protected strike. What must an employer prove if a dismissal is not automatically unfair? The employer must show that the dismissal is substantively and procedurally fair. And remember, in these cases, there's a high financial risk for employers if they found to have dismissed their employees unfairly to 24 months compensation. Then we move on to misconduct. Now, before we look at the changes that have been made in the draft code, we need to look at the history. How has procedural fairness evolved over time? Now, the first case to look at there is the Mashlangu versus CIM Deltec case, a 1986 decision. And here, the industrial court preferred a more formalistic and prescriptive approach to disciplinary inquiries. This led to the introduction of a very rigid checklist approach being adopted for disciplinary inquiries, which resembled the procedures adopted in a criminal trial. Then we got our current code. Despite the adoption of a simplified and flexible approach, the criminal justice model continued to categorize disciplinary processes. And then we get the Avril Elizabeth Home, which my two colleagues have already dealt with in 2006. And this case adopted a less formalized procedure in pursuit of a more flexible approach in dismissal laws. Following this decision, a more measured and pragmatic approach has prevailed, and reliance on the criminal justice system has slowly diminished. Now, is an employer required to always follow a formal disciplinary process? And the answer is no. The draft code provides that the purpose of a fair procedure is to ensure a genuine dialogue between employee and employer, whereby an employee is provided, and these are the words used in the code, an adequate and reasonable opportunity to reflect on and respond before a decision is made. In other words, your audi altrum partem rule, the right to be heard, remains intact. An employee should be afforded an opportunity to respond to allegations of misconduct, but no mention is made of formal hearings or inquiries. The draft code further provides that investigations or inquiries may be informal. Again, this is a welcomed change. Therefore, inquiries need not be formal or adversarial in nature. The nature of the allegation, as well as the size and the operational context of the employer, should determine the appropriate form and level of formality of the inquiry. The draft code's approach to misconduct cases aligns with the spirit of the LRA, which is for expedient dispute resolution. Employers should now be able to dispense with misconduct cases fairly, quickly, and less costly. However, it will be interesting to see how long it takes for employers to adopt a more informal approach. Now, what is a fair disciplinary procedure in terms of the draft code? Number one, employers must ensure that the charges are drafted with sufficient detail and clarity to allow an employee to understand the allegations and adequately respond to them, even if an informal process is used. And the draft code, in fact, goes a bit further and says sometimes it needs to be in a language that the employee understands. The employee should be notified, preferably in writing, of the alleged misconduct. They should be given a reasonable period of time to prepare and make representations on the misconduct and the sanction. And the employee should be assisted by a fellow employee or a trade union representative. Where reasonably possible, the employee should be provided with the opportunity to converse in a language that they are comfortable with. So, some noticeable changes. The draft code is silent on providing the employee with a written notification on the decision, and it's also silent in terms of giving reasons for the dismissal or reminding the employee of their right to refer a dispute. May employers dispense with the disciplinary procedures as set out in the code? And the answer is yes. The draft code allows for an employer to dispense with some or all of the guidelines, provided that the employer must be able to justify its departure should the matter go to the CCMA or the Bargaining Council. Now, what factors determine a fair sanction? Now, these factors have largely remained unchanged, and there's just one new addition, and I'll just quickly run through them. Number one is whether a workplace rule or standard was contravened, whether the rule or standard is reasonable and fair and valid, whether the employee was aware or could reasonably be expected to have been aware of the rule or standard, the importance of the rule or standard in the workplace, and the new insertion in the draft code is the actual or potential harm or damage caused by the misconduct. And then the other two factors have remained, whether the rule or standard has been consistently applied by the employer and whether dismissal is an appropriate sanction for the contravention. Now, when is dismissal an appropriate sanction? Dismissal is appropriate when the continuation of the employment relationship has become intolerable or the trust relationship has broken. Again, the chairperson should consider certain factors which have been set out. Again, there's just one factor that has been included in this section. So, number one, the nature of the job, the seriousness of the misconduct and its impact on the business, whether progressive discipline may prevent a future reoccurrence of the misconduct. And the new addition here is any acknowledgement of wrongdoing by the employee and their willingness to adhere to the employer's rules and standards. In other words, is the employee remorseful? And then the other factor, the employee's circumstances, including length of service, disciplinary record, and the effect of dismissal on the employee. So in other words, in a nutshell, the sanction must fit the offense after considering all the facts of the case. Is consistency a factor to be considered in assessing the fairness of dismissal? The rule remains employees involved in similar misconduct under similar circumstances should receive the same or comparable sanctions. But one of the changes in the draft code, it says that where the misconduct renders the employment relationship intolerable, dismissal may be justified even if there was inconsistency. In other words, different treatment may be justified in inappropriate circumstances, but one would have to go and look at all the facts and circumstances of the case. Must employers keep disciplinary records? Yes. Employers should keep records of the nature of transgressions, the disciplinary action taken, and the reason for those actions. And the reason for this is for accountability, and it also provides evidence if the dispute is taken further, and it's also there for the sake of consistency. Now, what if the employer's disciplinary procedure is embodied in a collective agreement or an employment agreement? The draft code is clear in that it does not supersede a collective agreement. The principle remains: what's contained in an agreement can only be changed by agreement. So employers and unions will need to decide whether they want to change and simplify their disciplinary processes. So now, in terms of, we're moving on to unprotected strikes. Can employees be dismissed for participating in an unprotected strike? Obviously, participating in an unprotected strike constitutes misconduct. Accordingly, employees may be dismissed provided that the dismissal is substantively and procedurally fair. In terms of substance, the employer must consider the following factors: the seriousness of the contravention, attempts by the employees to comply with the law, and whether the strike was in response to the employer's unfair, unlawful, or unreasonable conduct. And what's new here is that in terms of the seriousness of the contravention, the draft code has expanded on that and provided certain factors that an employer needs to consider. For example, the duration and timing of the strike, the legitimacy of the strike demands, the harm caused by the strike, and the conduct of the parties. What is evident here is the courts are going to need to provide clarity and guidance in this respect. Now, what process should the employer take before dismissing employees for participating in an unprotected strike? The draft code provides a step-by-step guideline or a checklist on the process to be followed by employers before dismissing employees. Number one, the employer should notify the trade union or employee representative of the strike, engage in discussions with the trade union or representatives to address the dispute, issue a clear and unambiguous ultimatum stating what is required of the employees and the potential consequence of non-compliance. And this is in line with the Labour Appeal Court decision in 2020 of AMCU on behalf of Ranto and Samancor, where the court said needs to be a clear ultimatum and advising the employees when to come back to work and what the consequences will be if they don't come back, that there will be disciplinary action and that they may be dismissed. All employees should be provided with a reasonable time to comply and reflect with the ultimatum, and the employer should only dismiss the employees after considering the conduct and any representations made. Another inclusion in the draft code is about collective misconduct. The employer can streamline the process by calling for collective representations on why they should not be dismissed. This is again a more flexible approach resulting in matters dealt with more quickly and less costly. Now, in terms of probation, what is probation? Probation is a period during which an employer assesses a newly hired employee's performance and suitability for employment before confirming the appointment. What is new here in the draft code is the word suitability, the new requirement. And things that would fall under suitability, 2 examples, is the relationship with clients, colleagues, and relevant stakeholders. Another one is the probationary employee's general attitude towards the work. Probation should not be used to deprive employees of the status of permanent employment. For example, dismissing employees at the end of a probationary period for reasons which are unrelated to their performance or suitability and replacing them with new hires is inconsistent with the purpose of probation and may be considered an unfair dismissal. In the past, they referred to that as an unfair labor practice, but here, in terms of the draft code, it's an unfair dismissal. How long should the probationary period be? The probationary period should be determined in advance in an employment contract and be of reasonable duration, taking into consideration the nature of the job, the time required to determine the employee's suitability for continued employment. So we always advise clients that when you're dealing with a junior employee, you generally would put them on a 3-month probationary period, as opposed to a more senior employee where they would have, for example, a 6-month probationary period to give them enough time to assess their performance and suitability. Now, what are the obligations of employers during the probationary period? Now, the one thing that I've always noticed in practice is employers or corporate clients will always call and say that they've employed an employee for a 3-month probationary period. It's now a week or a few days before the probationary period is going to end, and they want to terminate. They want answers. How do we terminate? They're not happy with the performance or the suitability. And immediately we ask them, have you consulted with the employee? Have you brought your concerns to the employee's attention? Have you engaged with the employee? And absolutely not. And that is a big problem. So when employers have probationary clauses in their contracts, they can't just sit back during that time period. They need to engage with the employees from the outset. So employers must provide employees with reasonable guidance, which may include instruction, training, counseling during the probationary period. This will all depend on the nature of the role and the size and the resources of the employer's business. Greater flexibility from the previous code in here, and the previous code adopted a checklist-style approach in relation to guidance and instruction. Can an employer decide not to confirm an employee's appointment after probation? And the answer is yes. However, the employee must be given an opportunity to make representations which must be properly considered by the employer. What standard applies to dismissals during probationary period? The draft code is aligned with case law, which says that arbitrators should be hesitant to interfere with the employer's decision to dismiss a probationary employee that has not met the performance standard or with the standards themselves. And this comes from the Labour Appeal Court decision of Ubuntu Education Fund, which reiterates this principle of reluctance on the part of arbitrators to interfere with operational decisions. Now, incapacity for poor work performance, I'm going to go through this quite quickly. What is the process to follow before dismissing an employee for work performance? This has largely remained unchanged. The employee should be provided with appropriate guidance, evaluation, instruction, training, and counseling, a reasonable time to improve, and an opportunity to respond to allegations of unsatisfactory performance. What are the guidelines in cases of dismissal for poor work performance? Again, remained largely unchanged except for one addition. So whether the employee failed to meet the performance standards, if so, whether the employee was aware or could reasonably be expected to have been aware of the required standards, whether the employee had a fair opportunity to meet the standards. The new addition here is the standards were reasonably achievable. Or in other words, for example, the targets are achievable or reasonable. Dismissal was the appropriate sanction. The code adopts a more flexible approach to the process when dismissing an employee for poor work performance. Now, does the same process apply to senior or managerial employees? And the process is different. A distinction is made for managerial and senior employees whose knowledge, experience, and expertise enable them to judge their own performance against the employer's expectations. And a single instance of underperformance in high professional skill roles may justify dismissal. But the bottom line is they must still be given an opportunity to make representations no matter what level they're in. And this section in the draft code, again, is aligned with the Somyo case. And in that case, he was an employee who was a manager for 6 years. He failed to vaccinate chickens in terms of a very strict procedure. This could have had disastrous consequences for the employer, and the Labour Appeal Court reiterated all the principles held in the draft code now, which is that the employee has the necessary knowledge and experience to appraise his own performance, as in this case, and a dismissal of a single lapse is justified where the degree of professional skill by the employee is so high and the consequences so disastrous that the dismissal would be justified in those instances. Then incapacity for ill health, injury, and other forms. How should incapacity be dealt with? If an employee is unable to work due to physical, mental health issues or injury, the employer needs to determine whether the incapacity is of a temporary nature and a permanent nature. If it's of a temporary nature, there are certain requirements that need to be met, and then the same for a permanent nature. I'm not going to go through all the requirements, except to say that mental health conditions is new in the draft code, reflecting the growing awareness of mental health cases in the workplace. Must cases of alcoholism or drug abuse be dealt with differently? Yes, counseling and rehabilitation may be appropriate for an employer to consider before dismissal. And the one thing that I've noted in practice, which is sad, is how employers are always reluctant to rehabilitate employees with alcohol problems. Is there any difference where an employee has a work-related illness or was injured on duty? Yes, in such cases, the duty on the employer to accommodate the employee is more onerous. This has also stayed the same in terms of the previous code. And what if the employee is imprisoned? This is a new section added to the draft code. Here, the employer will have to investigate whether the incapacity is temporary or of a permanent nature, the extent of the incapacity, and because it's a no-fault dismissal, possible alternatives short of dismissal. Now, what is incompatibility? This is now a new form of incapacity which may justify dismissal. Incompatibility, this is where an employee is unable to work harmoniously with colleagues or align with the employer's culture. The code has introduced this, but the courts will need to set parameters, guidelines, and more clarity in this respect. Now, the two cases dealing with incompatibility, we note that there's a very high test for employers in these cases. The first case was the Mpho Jabari versus Telkom decision. The Labour Court set out the factors that need to be taken into account when dismissing someone for incompatibility. They listed the employee must be made aware of the conduct causing the disharmony, who has been upset by the conduct. The employer should propose remedial action to remove that incompatibility. The employee must be given a fair opportunity to consider the allegations and to respond to the allegations. And the employee must be given a fair opportunity to remove the disharmony. And the other leading case is the Jocelyn versus Olivetti case. And in this case, it was a marketing manager who used to wear a floppy cricket hat to work. He sometimes used to come to work with a camera around his neck, and he carried 36 pens in his shirt pocket. The employer dismissed him for incompatibility. The Labour Court held that even though the employee was an oddball, his conduct was odd and eccentric, but it was harmless, and it did not justify dismissal. So employees need to be properly counseled and warned in such cases. Dismissal will only be justified if the incompatibility would cause disruption in the workplace or if it would cause an embarrassment to an employer. And then the last section is operational requirements. What constitutes dismissals for operational requirements? The code simply records the provisions as contained in Section 189 of the LRA and in the Code of Good Practice dealing with operational requirements. There's no new obligations imposed on employers. So dismissal for operational requirements, as in the LRA, it's for economic, technological, structural, or similar needs of the employer. And then, sorry, I missed a slide. And what obligations are placed on employers when retrenching employees? Since retrenchment is a no-fault dismissal, the employer must ensure that all possible alternatives to avoid dismissal must be explored, since dismissal should be last resort and employees should be treated fairly. When will a retrenchment be substantively fair? The reason for the retrenchment and the decision to select an employee for retrenchment must be related to the employer's operational requirements. In other words, there must be a genuine operational requirement. And then the process that needs to be followed, there's a checklist almost in the draft code. It basically says the employer needs to issue the Section 1893 notice, consult meaningfully and in good faith, that's important, with the affected employees with a view to reaching consensus. Seriously consider any proposals put forward by the affected employees or their representatives. Selection criteria, unless agreed upon, must be fair and objective, and the employer must disclose relevant information. And there is a note that employers covered by bargaining councils should ascertain whether there are council agreements regulating retrenchment processes. What are the main changes in the draft code regarding retrenchments? The draft code includes dismissals relating to operational requirements, which before was contained in a separate code. It's unclear whether that code is going to fall away, but it's anticipated that it should fall away. And it also introduces a Section 189.3 template, which sets out the issues which need to be included in the notice and which the parties have to consult upon. And then this is an example of the template, which I won't go through. And just in conclusion, as you're all aware, the draft code is a guideline only for employers. The code is not without its shortcomings, but it's certainly a step in the right direction in terms of the relaxation of certain processes. However, employers should be prepared to justify their departure from the draft code should the need arise. Thank you very much.
Thank you so much. Grab a seat right over there. Awesome stuff. Thank you so much, Ms. Chada, on that comprehensive presentation that you just gave us now. And I think I'm going to start things off, but also just by show of hands, let's get some participation from the floor so I can make a note of it before we continue. Also, so let's perhaps start with you, Mr. Chada. You made so many great points, specifically relating to the draft code of good practice. I know you said there were some criticisms leveled against it, one of those being that small businesses is not really defined. And you said it seems to also be silent on some would-be important nitty-gritties there. So what would it take to really fine-tune it and to make it fit for purpose, just moving forward?
Well, in respect of that small business, we'd obviously need guidance from the courts as to what is a small business.
Yeah.
And I suppose we're going to have to wait for case law to come out on that, unless amendments are done to the draft code before it comes into force.
All right. Let's get some participation from the floor. All right. Right here at the table on the front, please. If you can speak loud enough. But we have the microphone coming to you. There we go. Thank you.
I'm Adrian van der Walt. I'm from the Eastern Cape, from Gqeberha, from the university. GQ. Mr. Patelia, I just want to ask you a particular question. You referred to the procedural fairness, as it were, when on the documents, condonation applications are considered or rulings are made based on applications on papers, as it were. I just wanted to ask your view on if that is done, should the CCMA or bargaining councils set down the case for oral argument as well, or is that not necessary? I'll tell you why. Because, again, in the Eastern Cape, another bargaining council, not the Elrc, actually did not set it down. And on 2 occasions now, for a legal representation application and as well a condonation application, the fact that they were not set down for argument was regarded by the Labour Court in Gqeberha to be, the rulings were both set aside, purely on that basis. Do you agree with that?
All right. Let me get you to please make a note of that. If we have some more participation. Okay, from the side. Yes, ma'am, go ahead. And then I've noted you, sir, as well. All right, go ahead. There we go.
Greetings. Thank you for the presentation. It is appreciated. So my question was regarding the operational requirement. So I just wanted to check, is the employer allowed to renew the contract of like a fixed term contract in December, and then in January, then the employer says they have now done the due diligence, and then they issue an addendum to their contract. The one that was issued in December is saying you are renewed from the period of January to December 2025, but the addendum is saying you are now on contract for 6 months, and then few days after that, then you get, or 6 months later, you get a termination letter. The termination letter is saying you are being terminated because there is a permanent employee in another campus that doesn't have a load. So that lecturer, it's a TVET matter. So that lecturer will be transferred to take your place because you are on contract. So my question here is that allowed? And isn't it a due diligence, or the due diligence, is it supposed to be done before they issue a contract? Because that is my understanding, or the employer is allowed to do it after?
All right.
Thank you.
I think that would be for you, Mr. Chada, on procedure. Make a note of that, and then the last one on that side. Yes, go ahead.
Thank you very much, Chair. My name is Mompati Khalorale. My questions will be to Ms. Chad on the draft code. But let me start by indicating that my understanding of the promulgation of the Labour Relations Act when it started was to avoid the arbitrary action from the side of the employer against the employees. Now, I may be wrong. My observation is that we seem to be moving away from that fundamental principle of protecting the employees against the arbitrary action by the employers. I'm saying this because now, having looked at and listened to what is being proposed on the draft code of dismissal, it seemed to be making it much easier for the employer to dismiss the employees, because it's putting more of discretion to the employer on the element where the employee will have to make some representations and so forth and all that. Now, I'm just juxtaposing this code with what is being proposed on the amendments related to Section 186 that deals with the unfair labor practice, where there are a number of exclusions.
All right.
Some of those provisions are excluded, which should have constituted unfair labor practice under the guise of trying to align the ULP section with the code of dismissal. Are we not sliding backwards now in terms of the protection of the employees against the arbitrary actions by the employers? Thank you.
All right, sure. And there's also another hand here. Yes, right at the front. Go ahead, DG.
Thank you very much. Almost on the same, maybe I also need to introduce myself like Prof. I'm Matanzima Mweli from Basic Education. Almost in the same line as Mr. Khalorale, but maybe the difference between the two of us, we're wearing different lenses. He's wearing the lens of the employee, I'm wearing the lens of the employer. And my view is that the draft code of good practice on dismissal, the dispensation seems to make it even more difficult for employers to dismiss. That's my view. If you advertise a post and somebody says, these are the qualifications, this is my experience, I can do this job, and you discover that somewhere down the line the person is unable to do the job, why do you have to train a person? Right? The person said he can do the job. Particularly for managerial posts. For entry-level posts, I can understand. But for managerial posts, you still have to train and do all of those things. I think it's making it unnecessarily difficult, for employers
All right.
to just dismiss people who can't do their job. Thank you very much.
Okay. Over to you.
I feel like I'm being bombarded. Okay, so just in terms of the first question from that lady sitting in the front there, when fixed-term contracts are concluded, often it happens that the contract is concluded and then certain operational requirements happen and you would need to contemplate retrenchment. Provided you have a genuine reason or operational requirement, then you can embark on a retrenchment process. The one thing we advise employers is, in terms of the fixed-term contracts, always reserve your right to terminate for operational requirements.
All right.
Just in terms of the other issue, whether it seems to be easier to dismiss employees from that gentleman. My view is rights haven't been taken away from employees. They're still there. Procedural fairness has remained unchanged. It's just a bit more flexible, but at the end of the day, you need to consider the operational environment, the business, the transgression, the role of the employee. So there's certain factors that need to be taken into account. And then just in terms of, so you have to look at all the facts of the case. Every case will be dealt with differently. And then in terms of training employees, it's reasonable and only if appropriate. If you're bringing in an employee at a certain level and at a certain salary, you expect certain things from that employee. You expect them to know their job. So you wouldn't have to train them up from the beginning. So the reasonableness would come into play there.
All right. Mr. Patalia?
Well,
there's a question for you as well.
I really can't give an opinion on what the Labour Court had decided. But I think from a principle perspective, it's not a blanket principle that I was suggesting, that in all instances there would not be a requirement for a hearing. I mean, even in the instance where there are applications, there would be certain disputes of fact that cannot be resolved unless you listen to evidence, but that should not be necessarily the norm. And I suppose the variances is what's important there and what would be appropriate.
Chair, I know you want to add something to that.
Yeah. There's a January 2025 judgment, Kolomahle versus the Elrc, which deals with the same issue. But the Labour Court expressed quite serious views on it, because it held that the applicant was not given the opportunity in the hearing, whose application is dispensed of purely on papers, loses a fair opportunity to come and explain. I think we also need to understand that these applications for condonation are done sometimes by officials of the union or by the employee himself or herself, and there might be some issues that are left out. And particularly if you look at the Kolomahle matter, where there was a lot of information that was not in the papers that would have helped the arbitrator in coming to, the correct decision. And particularly, I think it was about 145, Teresa, you might know about it. It was about 145 days late, and condonation was denied. But, when it went to the labor court, there was an explanation that was provided, which covered the entire period. And on that basis, one of the biggest challenges was that arbitrator decided the matter on papers and didn't have the benefit of the information that was now put before the court. And it actually discourages the route of deciding condemnations on paper.
And I'm always quite fascinated when I'm having these legal discussions, Chair. You touched on the Motulwe case, where there's a perception that labor courts tend to often aim for procedural flexibility at times as compared to other courts. If you may, just how should practitioners weigh the balance and balance constitutional imperatives for fairness with the mandate for expeditious dispute resolution?
Yeah, look, these institutions, the bargaining councils, the CCMA, the labor court, the labor appeal court, all of them were set up for expedited dispute resolution. We're sitting with the two gentlemen 12 years later and 13 years later, and the matter is still not, finalized. But some of the things that I found interesting, and I had a chat with the JP about this case, is that the Constitutional Court takes a swipe at the labor court, but it does not take a swipe at itself, because they denied the guy twice. There's two applications that they denied. And in hindsight, when they revisit, they start looking at res judicata, and eventually they say, look, we have space to listen to this man. But they don't go back to say, we also wasted this guy's time. Because on two occasions, two of his applications were denied. But they, they take a good swipe at the labor court in terms of how it handled the matter. And the time factor involved in it, it's huge, and it's still not resolved, by the way.
Sure. And yeah, that's also another element to it. Mr. Patelia, you also spoke about, that landmark Bemal versus SABC case. In large-scale disputes, such as that one that you mentioned, where logistical constraints lead to what appears to be modified disciplinary processes, just how do you balance the procedural efficiency with the perception of fairness, especially from the employee's side as well?
No, it's an important consideration, because even collective disputes themselves, collective disciplinary inquiries, can be quite controversial, because it can remove the essence of fairness for each individual employee with their peculiarities in circumstances. Similarly, taking the route of listening to, hearing the matter on paper exclusively, these are matters that should be carefully considered by the employers, especially where there's a deviation from the existing disciplinary code and procedure. And I think proper advice should be taken. I think I would be remiss to say, this is the norm and it should be applied without then looking at the particular circumstances. Some of them, of course, what would be the practicality of conducting over 100 so forth inquiries. The factual issues were generally the same or similar. The legal issues that would have to be considered would be almost the same or similar. And there would be some relative consistency in terms of the way the matters would be dealt with, as it would be dealt with on paper. And then lastly, the representation was generally from one trade union. And so there were general factors that were taken into consideration that could be applied. However, again, in the instance where there was a requirement for oral evidence, that could have been accessed, either in particular circumstances initiated by the chairperson or then by the applicant themselves, that would have to, by the employees themselves. So I think there is greater room for flexibility, but it should be applied in exceptional circumstances, especially where there's a deviation from the code.
All right. Any more participation from the floor? Okay. I must thank you so much for your participation and engagement, and thank you so much for those presentations. Round of applause.
Thank you.
We'll be handing over the prize. Chair, prize given? Oh, okay. We'll come back for that a bit later on. Okay, ladies and gentlemen, we will now be breaking for lunch, and lunch will be about 45 minutes as we still have the third and final session for the day to come back for. So see you guys in about 45 minutes or so. Enjoy lunch.
South Africa's labor terrain is shifting faster, deeper, and more complex than ever before. And when the landscape changes, leaders must rise. Join us from the 11th to 13th of August 2025 at Emperor's Palace in Johannesburg for the Education Labor Relations Council Labor Law Seminar, under the theme, Adapting to an Evolving Labor Landscape to Promote Social Justice. It's a strategic gathering of policymakers, union leaders, educators, and legal experts converge to chart the future of work, rights, and equity. Education Labor Relations Council Labor Law Seminar 2025, where transformation begins. When labor evolves, justice must lead.
Okay, welcome back, ladies and gentlemen. We trust that you enjoyed lunch. So now we are in the third and final session for the day today. Okay. If I can ask you to settle down. Thank you so much. And very good afternoon. We trust that you indeed did enjoy lunch. You're still with us right here at the Education, Labor Relations Council Labor Law Seminar under the theme Adapting to an Evolving Labor Landscape to Promote Social Justice. Ladies and gentlemen, so as I mentioned earlier on, we are now on the third and final session for the day. And the bad news is that we are running behind schedule. So I'm going to be very strict with time. For our next presenters. So if I can ask you to keep it short and sharp, because we still have that engagement that follows your presentation as well. And a quick one as well on the speakers that will be coming up. Their profiles are available on the conference booklet, and all presentations will be available and updated on the website on the ELRC's website under the Labor Law Seminar portal. So this happens after each and every session. So do make sure that if you miss out on something, you won't miss out on a beat there. So ladies and gentlemen, I would like to now welcome Professor van der Walt as well as Dr. Maluleke to come and talk to us about unfair promotion disputes in public education. A round of applause.
It's a reality show. I think I'm ready. If the technical people are also ready. Good afternoon, Sanbonani Dimalang. Yeah. My name is Mugwena Maluleke, the General Secretary of SATU. And I'm with Professor van der Walt today to present few ideas around unfair labor practices, dispute in the education sector, as we revisit the 2,500 disputes that have already been dealt with by the Elrc up to 2022. 8 of them were about corruption, and the rest are about promotion and other things. So we're trying to look at the causes and impacts and strategies for fairness, if we're able to deal with that. That's what we'll be dealing with. So in introduction, flowing from the VHAM report, we saw the unfair labor practice introduced in 1979 in what we call Industrial Conciliation Act of 1956. Of course, initially as an open-ended, we saw the industrial conciliation developing new principle concepts and building knowledge about labor law at that time, to the extent that the jurisprudence that was known as the new labor law dealt with individual and collective law, labor law. So the principles, concepts, and everything that was developed by the industrial conciliation, some of them were taken into consideration. Breakthrough of 1994. And through the breakthrough of 1994, they had to develop a new Labor Relations Act, and the new Labor Relations Act had a Relations Act. And the others were obviously Chapter 2 of the Labor Relations Act, which also borrowed from what was already developed through situation where, Section 1862, which really consists of the following. That, say, from the, when I represent members and I say, they tell me about political intervention, I say, you know what? I don't know what that means. An omission is an omission. Even Tatemwell did not pay if their IQMS from the 1st of July, you must raise a hand. Before we leave here, and Tatemwell shall have paid. It's an omission of labor practices between an employee and an employer, so committed by the employer, and most relating to the promotion. And I don't want to be a new Labor Relations Act, which really developed from the work that has been done initially 1979 and continuously being done by the courts in our country. Local municipality versus the SALGA bargaining chamber, where we identify 3 types of premature referrals that basically cannot be regarded as unfair of the employer. Until there is an action, they cannot refer that particular dispute. Other cases is where head of department have decided to repeat the process, come and complain, but I have applied, and I think I'm the qualified candidate here, and therefore I need to refer a dispute around that and action. It's not a right. And so you have got to prove that the following substantial issues, like compliance with the minimum requirements of the advert, suitable, qualified. Prof is going to deal with that, including issues of gender balance and gender issues. Deal quickly, procedural fairness, something that you deal with on a daily basis here. So the question we want to ask is that, can arbitrators use trifling procedural irregularities to just arrive at the decision to make an award? Are there emerging tendencies that we see that arbitrators sometimes they just use these trivial irregularities just to find a situation where they can make an award? Does one go on digging just to stem the process, keep on digging and so forth? Don't we have to rely on the PALM provision that is there so that it suffices as the reasons for advertisement has been done, applications, and then the shortlisting is done, and interviews. Those are some of the things that really we have got to look into them as we learned from the Observatory Girls Primary School versus the head of department in Gauteng, and also the Douglas Ware School and Pelmilieu in the Noord-Kaap, Northern Cape. So one of the issues sometimes the arbitrators look at before they make that particular decision is that if we delay the appointment because there's an unfair labor practice, the dispute here, will it affect the child's interest? In other words, the paramountcy of the best interest of the child taken into account. Is the delay going to impact on the education in terms of Section 28 of our Constitution that grants the rights that cannot be delayed for the children to move on and learn? So, because I'm going to now move towards my professor here, not now, but this is where now the real story begins. What is an unfair promotion? A dispute. It's a grievance alleging unfair conduct by the employer. And I need to emphasize that because it's in relation to the promotion or demotion or training or benefits of an employee. So why it matters? I mean, seated here, would have to ask that 27 or 24,000 schools, principals, there will never be 480,000 principals. So there are 24,000 schools. Some schools have one principal, some have got 2 deputy principals, and of course the head of department. So they are not enough. And I'm here to negotiate that we have more in the management. So it matters precisely because these promotion processes shape career trajectory of people, but also deals with morale. And it's something that we have to work on after the COVID-19. There's a low morale, and there's really mental problems that we have got to deal with. So if the more the delays and more disputes that are created by the employer, we have to look into those issues because they also impact on the trust in our education institution. And unresolved dispute basically can create this arbitration, litigation, but also can be damaging to both our schools and our individuals in terms of reputation. And we believe these are the things that needs to be taken into account. The legal and regulatory framework of these promotion disputes is our Labor Relations Act, which defines unfair labor practices relating to the promotion on Section 186(2)A. But also the EEA, they call it like that, Prof, the Employment Educators Act of 1988, which grants the head of department authority to promote educators, of course subject to the school governing body making a recommendation for that effect, and that the Elrc collective agreement, we know about it, which provide guidelines to arbitrators to ensure that there's consistent in our decision making in the system. But constitutional principle, very critical, Section 195, public administration must be transparent, accountable, and must be fair at all material times. I see Prof has put some things there, you see, it's jibing around. So, few of the root causes of unfair promotion disputes, they may not be, be relevant for now, but obviously these are some of them. Procedural irregularities, nepotism and favoritism. There are schools where they don't know nepotism, okay? And we must accept and we must appreciate that. There are schools that know nepotism. Every Friday you deal with, they have appointed a cousin, they have appointed an uncle, and only happen in African school. That's where nepotism is known. Because in certain schools, when you go, where's Paul, my friend? In the former model school, a principal can be working with the wife or the brother. It's not nepotism because it's based on merit, right? It's based on qualification. Yeah, it's based on qualification. So there's a problem that we need to deal with. So some of the things is biasness, and some is based on discrimination, some is lack of transparency. Now we need to emphasize here, lack of transparency is the real problem, because sometimes when you don't have the information, you don't know what is happening, you will then be so, you can even lodge dispute because you don't understand what's happening. Insufficient panel capacity. This one is from Tatemuel and the head of departments that are here, that we need to ensure that there is sufficient capacity for the committees when they interview and shortlist and so forth, so that we are avoiding these particular problems. Prof, I'm coming. So what is the impact on educator morale when all these particular discrimination, nepotism, favoritism is happening and so forth? The motivation of our educators is declining, it's on the decline. But also it erodes the professional trust, and that is the only thing that we are relying on as a country from the teachers, to have this trust and so forth. To me, is the most important asset that you need in the education. So once it's affected, then you are going to have a situation where obviously it affects the performance of the students and so forth. Sometimes attrition of talent is that people join our education system and they leave before time because they have no trust in the system, because they feel that they cannot be promoted because there's favoritism, there's nepotism, and all those particular things. And please look at the emotional cost that it costs to those people who are affected around this particular issue. So, what are the institutional effects on the school and the outcome of the student? Leadership instability, when we're delaying to a point because the process of the dispute is taking long and so forth, it really causes instability in the schools. I come from a school that has been having no principal for how many years in that? From 1996. So, compromised teaching quality is also some of the things that we are going to be declining student achievement, and I think all of us love our children, love our students, love our country, want them to perform, and for us to do that, we have to do that. There's one thing, Prof, that we always don't look at in the education as an institution. How important is the reputation of that particular institution? So it damages the institution and so forth. You find that teachers say, I'll never apply to that particular school. I'll never apply to that particular college and so forth. Why? Because you cannot trust the processes there. They are very problematic. Last, what are the international perspectives on the topic that we are dealing with? So we're looking at Finland and Canada, and we find that there is a transparent online tracking, for the candidate. So you know what's happening. It's external audit on promotional panels. Okay? You look at the United States, they depend more on their qualifications. They say, for you to be a principal, you need to have a master's degree, and so forth. And then you're looking at Hong Kong that says, we need a balanced scoring system, and so forth, combining professional qualification, experience, and peer reviews. I think somebody was talking about it when I came in today around this particular matter, because there are 4 things is that, one, when you look at interviews and so forth, you are going to look at experience, you're going to look at the qualification, you're going to look at the performance at the interview, but also there is an issue of equity. And I think, Prof, you'll deal with that. There's an issue of equity around these particular issues. Oh, the time out. So I'm done. Over to you, Prof. Who's timing me?
Thank you. Short time. Thank you. Must give me that, please. Thanks a lot. Now it's from the beginning again. Yeah, let's see. Right. What I intend to do is just briefly go through some important cases about the unfair labor practice. It's fine. It's fine. Yeah, it's fine. Unfair labor practice relating to promotion. And the first one I want to talk about is the Education Labor Relations Council versus Department of Education, which is a very important labor appeal court judgment. And this case was actually argued before the Labor Appeal Court by your very president, Dr. Bono. So he argued the case, there's an interesting backstory to this. Sometime before, in 2020, a judgment was handed down in the Labor Court in Gqeberha, and it was Judge Dennis Davis. I mean, he's very well known. He's also a TV actor. He decided in a similar type case of the Department of Rural Development and Agrarian Reform, where Luvuyo, Dr. Bono appeared, that the department, the GPSSBC, the Bargaining Council, had no jurisdiction to entertain or set aside an appointment on the basis that it should have been referred to a review, administrative review, to the ordinary courts. So that was the finding there. That was 2020. But now, in this matter, this case, the original case of Mr. Betani, was that at the Labor Court had the same finding, that the ELRC in this case had no jurisdiction to entertain and set aside an appointment by the Department of Education. And then the ELRC took that on review, because that was very important for the ELRC, because in the ELRC we have the Collective Agreement 3 of 2016, where guidelines are given to arbitrators and to the parties in regard to unfair labor practice relating to promotion in public education. So Luvuyo then argued that. The first issue is that in chambers, he tells me, he mentioned to Judge Davis, who was then also on the bench of three, what have I done? Three, typical me, that's fine, of 3 judges, that Davis was then sitting as a Labor Appeal Court judge in that very case. So he raised the point, but you have found against me on the same principle in the Labor Court. So Judge Davis said, no, don't worry, I've read the papers now. And so the case then overturned the judgment, or the previous judgments, really that these type of cases must go on a review before the High Court or Labour Court. So just briefly, the facts in this case were that Mr. Betane and Ms. Motoma both scored 92 and 90 points respectively in their interviews. The school, by the interviewing committee, the school governing body ratified the decision and recommended Mr. Betane for appointment. However, the HOD did not follow the SGB's recommendation and appointed Ms. Motoma. Can I go on? Thanks. It's not. Citing gender imbalance at the school as the primary reason. So Mr. Betane then referred an unfair labor practice dispute to the ELRC. The arbitrator ordered the DOE to appoint Mr. Betane and set aside Ms. Motoma's appointment. The DOE then lodged a review with the Labour Court. The court found the DOE's conduct constituted administrative action, which could only be reviewed by a court. And then the ELRC took this finding on appeal to the Labour Appeal Court. The Labour Appeal Court concluded that the ELRC is a designated bargaining council for the education sector. The court also referred to the ELRC Collective Agreement 3 of 2016, and that specifically states that its purpose is to ensure parties and panelists that they understand what is expected of them in relation to unfair labor practice disputes concerning promotions. So the parties in this agreement then, which includes any employee covered by the Employment for Educators Act, bestowed the power to determine promotions disputes to the ELRC, and as a result of that, the ELRC is entitled to determine unfair labor practices concerning promotions, and that's the authority that collective agreement and the function that the ELRC fulfills in determining unfair promotions is accepted in our law. And it's not the line of thinking of labor court, in previous labor court cases, that these type of disputes must be administratively reviewed is not the law anymore. Then in a case that was handed down now in July, the Department of Education of the Northern Cape versus Reuben Forbes Crow, the Labour Court followed the LAC's judgment when a jurisdictional challenge was raised. In this case, the appointment of the second respondent, Ms. Sylvie Walker, was set aside, and the head of department was directed to promote the first respondent, Mr. Reuben Forbes Crow, to the position of school principal with retrospective effect. The court referred to Section 1934 of the LRA, which provides that an arbitrator may determine an unfair labor practice dispute on terms he or she deems reasonable, including reinstatement, re-employment, or compensation. The court held that the arbitrator has wide powers as long as they are reasonably exercised, includes the power to make the order he did. In addition to that, the ELRC Collective Agreement 3 of 2016 further binds the employer and advises arbitrators on remedies, including setting aside the appointment of a successful candidate. So the DOE in this case contended that the arbitrator exercised the power vested only with the HOD in terms of the Employment Equity Act. You know that in terms of, not the Employment Equity Act, Employment for Educators Act. In terms of that act, the final power to appoint lies with the HOD. But in terms of Section 210 of the Labour Relations Act, that section provides that if any conflict arises between the LRA and any other law except for the Constitution, the LRA will prevail. So the court then concluded that although that is determined, that the right or the authority of the HOD to make appointments. The LRA overrides that, that gives the arbitrator the right to override the decision of the HOD and set the appointment aside. And in fact may order that the other candidate, the applicant, is appointed to the position. So that is now clearly established in our law. Then the court turned to whether in the particular case, remember it was a female that was appointed, she was not ranked first by the SGB, and the male who was ranked first was not appointed. He was the aggrieved employee, and the arbitrator found in his favor, and this case is now on review before the labor court. So the court held that this Mr. Crow, the employee, had to prove the unfair labor practice. Remember, the onus is on the applicant, on the employee. What was in dispute was whether the HOD had acted unfairly by not promoting him, given that he had the highest score and the SGB's recommendation. He had long service. He had something like 37 years service at the school and was an HOD and performed exceptionally well. So sections 6.3 and 7.1 of the Employment for Educators Act outline the roles of the SGB and the HOD. While the SGB's recommendation is crucial, the HOD may depart from it under certain circumstances, but must provide evidence to rebut the inference of unfairness. So if the applicant then brings evidence that on the face of it, prima facie, it appears that the HOD had acted unfairly, then the onus is on the HOD to rebut that prima facie inference. In this case, the HOD did not testify. An HR official testified, but could not explain what the HOD did or why she did it. So the court actually was criticizing the witness of the department on the basis that he did not contribute anything to the case. And he was called, the only witness called by the department. The arbitrator then concluded that there was no evidence before him that the HOD had in fact exercised the discretion at all. The fact that the HOD provided no reasons for a decision and also did not respond to a subpoena. She was subpoenaed by the applicant, but she did not come to the arbitration, undermined the employer's case. The argument of the department was that there is an internal directive that provides that HODs may not be subpoenaed for arbitrations and court cases. And the court said, but that's not possible. In terms of section 142.1 of the LRA, that overrides an internal directive. An internal directive cannot suggest that an HOD may not be subpoenaed. So the arbitrator concluded, therefore, that the appointment of the lady, Ms. Walker, was arbitrary and capricious. The department failed to discharge the evidentiary burden to justify the departure from the SGB's recommendation. And because of this failure, the labor court, also made a cost order against the department. So it's quite important then that, oh yeah, another thing I forgot. In this case, the employee, in fact, asked reasons before he launched the case, before he referred the case to the Elrc, asked for reasons from the MEC why he was not appointed, and those reasons were just never forthcoming. So that was also a factor that was taken into consideration. So he made out a prima facie case, and the department was not able, with what it presented at the arbitration, to rebut this prima facie inference. So, yeah, I'll come back to that, but you see, it's therefore very important for the department to take a deviation from the recommendation by the SGB very seriously and consider it to consider the appointment in such a way that if there's deviation from the person who is in fact recommended, that should be few and far between. So if there was an honest interviewing process, there was an honest ratification by the SGB, the department will be hard-pressed to deviate from that recommendation. It was the department's decision, the MEC's decision, must be proved to be rational. Now, if I look at this case and the Labour Appeal Court case, they both were cases where a female employee was appointed and preferred above the male. And there's nothing wrong with that, because if you look at 6.3 and 7, Section 7 of the Employment for Educators Act, the equal representativity and equity must be considered. So you can presume that perhaps in the latter case there was no evidence of what was considered. So you can presume that was considered, but I mean, there was no evidence to that effect. I think it can be quite readily overcome if the HOD in fact exercises the discretion and does not just only rely on employees and she does or he just signs the decision. It's an important decision that affects the lives of people, so therefore there must be a rational explanation from deviating from it. Then I just want to end off, well, there's just a few cases that I picked up they're all on the website. It's quite interesting if you don't know. You can actually source all the ELRC arbitration awards on the website of the ELRC. You can read every single arbitration award that's rendered by the panelists of the ELRC. So I just went through that because it's quite clear that even now, I mean, we've got this remarkable collective agreement, which is a collective agreement that establishes the guidelines, 3 of 2016, guidelines with detailed references to cases for the benefit of arbitrators and users, for the department and for the trade unions. So the tools are there to act fairly. So it's therefore surprising that there's so many unfair labor practice cases that are still referred to the ELRC, and in so many, the arbitrators make compensation awards, which is really unnecessary if the procedures are just followed properly. So now you have a situation where a person is not successful, takes the case to the ELRC and get additional compensation. I mean, it shouldn't be like that, but that's the point. So the department then again must be very careful in ensuring that procedural fairness is actually adhered to in the appointment process. So the other one, the next one, I suppose I should move. Yeah, there's this one. This is an arbitration award of Naptosha on behalf of Ms. Pillay. Again here, Ms. Pillay claimed an unfair labor practice after not being shortlisted, in this case as deputy principal, despite 37 years of service, 15 years as a departmental head, and experience as acting deputy principal. She alleged that she was deliberately underscored due to strained relations with the interview committee. So there the alleged unfairness moved back to the school, to the SGB, because remember the interview committee is drawn from the SGB. The respondent claimed that the process was fair, transparent, and that correct procedure was followed. But the arbitrator found, and these are all cases from 2025, recent cases, found procedural and substantive unfairness. Procedurally, the panel failed to justify why a highly experienced candidate was not shortlisted at all. Do you see, in this case, it's now the department. Why would a person with 37 years of experience, 15 years as a departmental head, and the experience of acting deputy principal not be shortlisted? I mean, that raises eyebrows. The arbitrator found if the department cannot justify what that person was not shortlisted, there was no justification for it, it wasn't even raised, then it's procedurally unfair. Substantively, there were serious inconsistencies in how the scores were awarded. A reasonable inference of bad faith was established, as it was likely the panel knew which anonymized CV belonged to the applicant. That was the evidence before the arbitrator. And then again, the evidence is before the arbitrator, and the department failed to rebut several of the applicant's allegations. For instance, there was allegations concerning identical CVs and underscoring. I'll finish soon. So, because of personal bias, the non-appointment, or not the non-appointment, there was unfairness. There was an unfair labor practice concerning promotion. But now that's typically what arbitrators do. The applicant was granted compensation equal to 6 months' remuneration. Okay, so there's a significant compensation granted to her. We could argue that she didn't prove that she was the best person for the job. Remember, she wasn't even shortlisted. So therefore, there was a significant compensation given. In Natu versus Simelane, this is the head of the Department of Education, KwaZulu-Natal, the unfairness was that the school governing body was in a bit of a disarray. And the consequence was that the department did the interviewing and the recommendation to the HOD. And the court found that this STB has exclusive authority to recommend candidates. And the power cannot be delegated to the department. And the HOD acted without proper jurisdiction by accepting the delegated power and appointing the principal without a lawful STB compensation. In this case, then, the department was ordered to restart the process with the STB fulfilling its statutory role. So the appointment was set aside. In Elliot Katsenga case, sorry, I'm almost done. Is it moving? Simelane, we've done Simelane. This doesn't move. In this case, Mr. Katsenga was a Zimbabwean citizen, but he had permanent residence and is entitled to work there in South Africa. He had significant experience and qualifications and was not appointed, although he was shortlisted because he met the minimum requirements, and the interviewing committee, in fact, recommended him as the first candidate. But then the STB changed the order. So the STB, without consulting the interviewing committee, changed the recommendation to the department. And in the arbitration, it was clear that the main reason for this change was that Mr. Katsenga was not a South African citizen. And the person who was recommended had absolutely no experience in the subjects that he had to teach in the higher level of the position, where Mr. Katsenga was fully qualified and experienced in those subjects. So again, the matter was set aside, the appointment was set aside, and the interview process was ordered to be redone by a properly constituted committee, excluding the biased officials. Then the last one is Van Rooyen versus Department of Education in the Eastern Cape. In this case, the STB recommended the applicant, Mr. Van Rooyen, for a principal post after he scored the highest. The acting HOD with authority rejected this and appointed the third-ranked candidate, citing two reasons: an alleged family relationship between the applicant and a panel member, and the superior managerial experience of the appointed candidate as a deputy principal. Now, Mr. Van Rooyen did not have experience as a deputy principal. It was a principal post, and the person who was appointed then was a deputy principal from elsewhere. The first point about the bias was just a ruse. The person was very far removed family-wise, and Mr. Van Rooyen and the person didn't even really know that they were families. And interestingly, that person scored Mr. Van Rooyen the lowest of all. So it couldn't have been biased. So the court, as the arbitrator said that, you remember these are arbitration awards, said that that was not, that couldn't have been, there was no bias. But the arbitrator found that the HOD, acting HOD's discretion was improperly exercised because he created a new requirement. In other words, he said, no, we must appoint only people with, who had already been deputy principals and not HODs. So from the evidence, it was clear that he inserted a requirement, which is not a requirement for the position. Now, interesting in this case, the court, the arbitrator did not set the appointment aside, but citing the best interest of the child under Section 28 of the Constitution, the arbitrator found that removing the new principal would destabilize the large school, and to remedy unfairness, the arbitrator ordered compensation of 4 months, so 4 months' salary. So that's a little bit of cold comfort to the applicant to the case. So in conclusion then, from my point of what I've raised, it is that the department or the MECs must take care in considering the recommendations of the SGB. Spend time on it with their senior managers, employees, to determine seriously and rationally, particularly if there's a decision not to appoint the first-ranked candidate. And the second point is then the department, again, sorry, and SGBs probably need still officials there need training in the process, because at this stage, so long after this has been a known process, the ELRC is faced with significant numbers of unfair labor practices, which, particularly if it's procedurally unfair, should at this stage not be the case. Just as a final thought, we have this wonderfully developed jurisprudence on promotions, particularly in the public sector. The unions, I want to warn the unions, they must check at the proposed amendments. All this jurisprudence may be washed down the river into the sea if the proposed amendments concerning promotion is taking effect, because there's a suggestion or recommendation that the first unfair labor practice, the one concerning promotion, demotion, benefits, that is purely deleted in terms of the amendments, which is for, I mean, just be careful that with slight changes in the Labor Relations Act, that whole development jurisprudence on rights are just not washed away. So I'm just warning the unions. Okay, thank you.
Thank you so much, Prof. van der Walt, for that comprehensive presentation there. Ladies and gentlemen, would now like to call upon Mr. I. Israel Stem, who's the CEO for Labor Law Management Consulting, for his presentation on the misuse of legal technicalities that endangers the tightrope balance. Round of applause.
Thank you.
Thank you. Good afternoon, everybody. We've already heard that this conference is about social justice. And the concept of social justice has been adopted into the labor relations dispensation very strongly under the heading of the word or concept of fairness. But the problem is that, especially in the education sector, employers, people who are in management like HODs, are required to comply with the rights and interests under the heading of social justice, not only of employees, but also of learners. And that poses a problem because the interests of these two different groups can often clash. And that is why we have this tightrope that is mentioned here. The management is walking the tightrope, trying to satisfy the interests of both groups. And that is a perilous effort. So, 30 years ago, our old labor dispensation was replaced by one that focused on protecting employees and leaving employers largely to fend for themselves. It was felt that for too long, employers had been able to rule the roost and in many cases, exploit employees, and so the new legislation intended to bring that to an end. So the trade union movement, together with the ANC government, pushed through labor legislation aimed at attaining for employees fairness at the hands of employers and quick and easy redress for unfairness. That's very important. The preamble to the Labor Relations Act states that one of its purposes is to provide simple procedures for the resolution of labor disputes. This is to help make it easier and fairer for employees to get their interests looked after. And this, I want to stress, is the core of our new labor dispensation that came into effect 30 years ago. The bodies that are responsible for this, that's the CCMA, the councils, including the Elrc, and the labor courts, take this responsibility very seriously. The CCMA and bargaining councils use processes that are much simpler for employees to make use of, and the system rests on the principle that matters must be decided based on the facts of the case with a minimum of technicalities. This will then assist employees who feel hard done by to get the case dealt with based on the facts, to avoid employers using technicality after technicality to frustrate the employees. So employers that try to abuse technicalities and to frustrate the employee are likely to come off second best in South Africa's labor dispensation. So if you're an employer and you have a case, whether it's an internal case, CCMA, Elrc, Labour Court, focus on the facts of the case, the fairness of the matter, and not on technicalities. If an employer argues that it wasn't legally required to seek a post for a retrenchee in a sister company because that company had a separate corporate registration, the council or the CCMA are going to rule against you. So the employer can't evade its responsibility because of what is called the corporate veil. That is a technicality. If the council sees this as one business even if there are separate companies in the business. That's not going to work. So where there's a retrenchment, the employer must look throughout its entire business to try and see if they can place the employee. So the employer using this technicality to avoid liability is going to find itself in big trouble, because the principle that we work on is fairness and not who's got the best technicality to argue. So in the footwear trading case, the employee was dismissed and won an award from the CCMA for compensation. And this award was made against a company called Fila, a company that was closely associated with footwear trading. So the company did not comply. The employer did not comply with the compensation order, and the employee didn't get compensated. So the employer applied to the Labour Court to make the CCMA's award an order of court. And Fila, who was the respondent in this case, told the court that it was dormant and that footwear trading had taken over certain of its assets. I'll come back to that. The employee also sought an order declaring Fila and footwear trading to be co-employers and therefore jointly and severally liable. So that strengthened the employee's hand. But footwear denied that it was joined to Fila, and it claimed that it was merely carrying out administrative tasks for Fila. As it was saying, we're just a service provider. We're not part of the same business. But the court rejected this and declared the two companies jointly and severally liable for the compensation payment. And so footwear had to pay because Fila didn't have the money. Footwear trading then appealed against this to the appeal court, which found that the legal personality may be disregarded where a corporation is a mere alter ego or conduit of another person. You can't hide behind the corporate veil, and that kind of technicality isn't going to work in the interests of fairness and social justice. Footwear was in control of the business, even if it was a separate legal entity, and not technically the employer. And it was therefore jointly liable. Another kind of technicality that's used, a ploy that employers use, is to argue that employees' employment terminated due to a requirement of law. So they're saying, we didn't terminate this employee's employment. We didn't dismiss him. The law did it. A requirement of law made his employment come to an end. So this is the Bithri case, where Bithri was against the Department of Health in Gauteng. And Bithri was appointed as a registrar at the beginning of 2017 on the basis that she'd be doing clinical work for the employer's hospitals and would for a period of 5 years be enrolled to study at Pretoria University. Her contract contained no end date, but the employer claimed that Bithri, by operation of law, a requirement of the Health Professions Council, had only been appointed for a 4-year period. She'd only been appointed for a 4-year period based on a requirement of the Health Professions Council. So after 4 years, the employer notified the employee that a post was coming to an end on the 31st of December 2021 on the basis that the Health Professions Act prohibited the continuation of employment of employees after 4 years unless an extension of employment had been approved. So here was the technicality. The employee lodged an unfair dismissal dispute with the Public Health Bargaining Council. The arbitrator ruled that the employee had not proved that she'd been dismissed because she had not been appointed permanently and because the registrar had to vacate the post if she had not passed her academic study course after 4 years. And Bithri had not done so. So the employee took this on review, and the employer's claim that Bithri's employment had been terminated by operation of law was invalid. The employer had created the problem by its failure to ensure that the employment contract was clearly worded as regards the employee's temporary or permanent status and academic obligations. So Bithri wasn't even aware via the contract that this was a requirement. It was a technicality hidden in the requirements of the Health Professions Council. Therefore, the dismissal had been procedurally and substantively unfair, and the employer was ordered to pay the employee 8 months compensation. A very expensive lesson. In the case of Sakavu versus Putini, the case report doesn't provide the reason for or circumstances of the dismissal. It wasn't directly about the dismissal. Putini obtained an award from the CCMA reinstating him, but Sakawu failed both to contest this award and to comply with it. So the employer in this case was the union. The employee was a union employee. And Sakawu failed to contest the award. A whole year later, Putini lodged the Section 158 application to the Labour Court to make the reinstatement order an order of court. And the court granted that application and awarded the costs against the employer, Sakawu. The employer then lodged an appeal at the Labour Appeal Court against the Labour Court's decision. But the primary basis for this employer's appeal was that Putini had lodged his Section 158 application extremely late. So it was a technical challenge that the employer lodged. The court dismissed this on the basis that it was a technicality and that the rule discouraging such delays was to be implemented flexibly. So the delay was long, but it was seen by the court as a technicality, and it said that we have to be flexible in the interest of social justice and fairness. The court dismissed the appeal and ordered the employer to pay the employee's costs. Now, in my view, if the employer believed that its case in the dismissal matter itself was weak, it should either have settled the matter or reinstated the employee. On the other hand, if the employer believed that it had a strong case in the dismissal matter, it should have applied to the Labour Court for a review of the reinstatement award. Then we wouldn't have been talking about a challenge on a technicality. It would have been a challenge on the central merits of the case. The employer's loss in this matter appears to have stemmed from its failure to do what it should have done. Instead, the employer relied on a technical appeal, and that is why it lost the case. So we've been talking about technicalities and why they shouldn't be used. And just to recap on that, what we're looking at here is a situation where a technicality goes against the basic precepts, the basic purpose of our labor dispensation, which is fairness. Now, employers will often try to use technicalities because they want to carry on with the business. They don't want to spend a lot of effort and time disciplining employees or going to the bargaining council or the labor relations council or the CCMA. They just want to get on with the job, for example, of educating learners. And this is where the tightrope comes in, as I mentioned earlier. Unfortunately, employers are required both to make sure that they run their workplaces effectively and productively, that factories get run properly, that production runs properly, or that learners learn. But they still have to comply with the law. So that is why employers are on the tightrope. They have two competing pressing obligations: to comply with the legislation that greatly protects employees. We have the most protective labor legislation in the world in South Africa for employees. But we still have to ensure that the workplace is productive. And that is our tightrope. Because where management focuses too much on productivity, effective workplace, effective teaching, effective production, it ends up breaching the tough labor laws. Conversely, where employers comply strictly with the law, productivity can suffer. If you're spending hours and months and weeks and days on legal procedures, labor law procedures, then your resources to run the business or the institution are depleted because they're being diverted. But all South African employers have got to learn to walk this tightrope, not to fall off on one side or the other. It makes it, because it is a shaky tightrope, it's very easy to fall off on the side of legal compliance or effective productivity. So as we've seen from the case law, the use of legal technicalities to deal with labor matters doesn't assist the employer. It just makes things worse. It increases the chances of falling off this tightrope. Employers who wish to avoid this danger should reject the use of legal technicalities and instead obtain the 48-part labor law video series called Walking the New Labor Law Tightrope. Then we will be able to achieve both workplace productivity and effectiveness on the one hand, and still comply with the laws that are so protective of our employees. Thank you. I don't know if there are any questions. Are there questions?
We'll get to the question and answer session a bit later on. I just quickly stepped up. Ladies and gentlemen, thank you for that presentation. I think I'm going to ask us to stand a bit before we move on to the next speaker. Because I think after lunch we get a bit, maybe stand up and stretch just for a few seconds to get us ready for the next speaker, because I think we need it a bit. Yeah. Yeah. Just a bit of a stretch. after that, before we get ready for the next presentation. You ready, my good sir? You good to go? All right. Okay, thank you so very much for that presentation, Mr. Israel Stem. I'm going to ask you to take a seat as well here with the esteemed panelists because we'll be opening up the floor for some questions and answers a bit later on. All right, are we still good? Feeling great? Lovely. Did that stretch work at least? I'm glad it did. Okay, so now we'll move on swiftly right along to our last presenter for the day, ladies and gentlemen. Before we get to the question and answer session, I'm going to ask Mr. Kotoi from the Nelson Mandela University to give us his presentation on the termination of unlawful employment contracts in the context of employment in the public service sector.
So this is next, right?
Yes, sir. So this is previous and this is next. 40 minutes on the dot.
How much?
40 minutes.
Oh, that's good. Sure.
Thank you.
All right, colleagues, a very good afternoon. It's always tough to bowl the last over because you're not expected to concede runs. You're expected to get a wicket. And be that as it may, we will start riding the horse. Now, before I start my presentation, I'm always reminded when I deal with cases that involve the state as an employer of a comment that was made by the late Justice Yvonne Mohoro when she said, the state departments tend to operate in silos. What happens in one division, rather in one department, and when that department gets caned by the courts, other departments don't seem to take heed of the fact that the same principles that were distilled there might apply to them. And you will see this in the discussion that we're going to be having. And I'm pretty sure some of you might be wondering as to what is the logic of the topic termination of unlawful employment contracts, and then I make specific emphasis on the public service sector. And my starting point, and in order to make my job double easy, is that when Cindy approached me to say, can I make a presentation, you always have to battle now to say, why do I choose the topic? And there's an unwritten rule in our faculty that you don't go home without going through that SAFLI website to check recent developments in case law. And incidentally, I bumped into that judgment which is there, the Njibu and others versus MEC for Health, which is a new leaf judgment. I think it was delivered in 2024, and then it was taken on appeal, and the full bench made a decision this year, I think around May, if I'm not mistaken, but it's this year, so it's quite a new judgment. But what's interesting about that judgment is that it dissects the constitutional provisions that we already know. And that's why my outline of the presentation is more or less about what does sections 123 and 172 tell us? What about this principle in law that the courts may not enforce illegal contracts? And it's based from that requirement in law that contracts must meet that requirement of lawfulness. How have the labor courts dealt with those situations? I won't spend much time on the LRA, the controlling law, because we've been taken through that extensively today. I'll spend some time on the Discovery Health versus CCMA because it's quite instructive in this case, and then I discuss the case, and then we analyze it, and then after that, we go home because we know that we are standing between you and the cocktail. Now, if you look at Section 1 of the Constitution, it emphasizes this principle of legality, the rule of law. You can read it for yourself. And then if you look at Section 23, Section 23 of the Constitution guarantees everyone the right to fair labor practices. And if you look at how the courts have interpreted the meaning of the term everyone, they have not applied it restrictively. They've always emphasized that everyone should be interpreted to mean exactly what it seeks to mean. And you need not look any further than the State versus Makwanyane Concord judgment, which had to deal with the death penalty. And it made that comment that everyone has a right to life, including the most vile of us. And they adopted that approach of saying the term everyone must be interpreted not restrictively, but expansively. Now, what is also going to come to the fore is if we say the Constitution is founded on the bedrock of the value of legality or the rule of law, what does a court do when it decides a matter and it finds that that matter is, that contract, if you will, is tainted by illegality, it's unconstitutional, or it's tainted by invalidity? And 172 does say the court must declare that conduct invalid. But then it goes a step further to say, when a court makes that decision of declaring that conduct invalid, they also have the discretion to order any remedy which is just and equitable. And I think for those who followed the Public Service Administration versus Nehau judgment, wherein there was that collective agreement that was tainted by illegality in terms of the fact that it breached the PSA regulation, I think it's Regulation 79 of particular importance. The hope was that the Concord would declare the collective agreement invalid, but at the very least say, we are going to make this order which is just and equitable. And I think the justice who had to decide that matter, Judge Madondo, didn't really find that option attractive of issuing an order that is just and equitable. Now, obviously, I'm speaking to the converted. You know it better than I do that the fundamental question now that arises is when we interpret Section 23 of the Constitution, which says everyone has the right to fair labor practices, and then we juxtapose it against Section 1 of the very same Constitution, which says we must always make sure that we adhere to the core principle of the rule of law, or should I say legality. Then the issue is, where does this stand in the employment context? The LRA is very clear. If you're an employee, you have a right to be dismissed fairly, both procedurally and substantively, and in the event that your dismissal is found to be wanting on the front of not having been accorded the so-called audi altram partem principle, or the hearing, that dismissal will be procedurally unfair. If the employer doesn't fire for you for an acceptable reason, that dismissal will be substantively unfair. Now, when it comes to case law, the slides will be distributed, I'm assured. One must always be mindful of two judgments which are very popular, but there's actually a third one, Sithole versus MEIBC, which also endorses the principles that are laid out here, in the sense that in the Discovery Health judgment, there was an issue with the work permit. The employee was employed and the work permit was not so valid. And what the employer did was to terminate the employment contract on the basis that, look, there was an infringement of the Immigration Act in the sense that there was no valid work permit that Lanceta had or the employee had. And what the aggrieved employee did was to refer a dispute to the CCMA. And at the CCMA, there was a jurisdictional point that was raised on the basis that the contract was tainted by illegality. And what the employer was arguing there was the contract was void ab initio, and then the CCMA did not have jurisdiction to determine that kind of a dispute. And their argument was to say, because the contract was tainted by illegality, Mr. Lanzetta could not benefit as an employee in terms of the LRA. The Immigration Act, which was actually at stake here, it actually states there that you can't really employ a person without the proper papers, if you will. And Section 49 also makes reference to the fact that if you knowingly employ a person who's not having the correct papers, then you run the risk of those sanctions that are there, the convictions and fines and all such stuff. Now, before I jump into the Standard Bank case, those who follow case law will also know another judgment which also tackled this issue of illegality was the Kiley versus CCMA, where if you take the Discovery Health matter, the work that Lanzetta had to do, there was no issues with it. It was only the permits that was problematic. But in Kiley versus CCMA, the very work itself was problematic because it's not sanctioned by the Sexual Offences Act. And when the matter went to the CCMA held that, look, we do empathize with you, but we can't come to your rescue. And the issue there is Kiley was the applicant there, was employed as a sex worker, if you will, and we are told she was given an instruction which she refused to perform, which is normally your insubordination, if you could take it along that line, but the employer just terminated the contract on the spot. Now, the CMA disavowed any reliance on by saying, look, we can't help you because if we help you, it means we'll be condoning illegality. And the matter went to the labor court, and I think it was Judge Cheadle, who also said, yes, there was some kind of emotional sympathy for Kiley, but the work that she was doing was not sanctioned by law, and to entertain her claim would amount to conduct that would be contra bonum res, contrary to public policy. And those of you who follow that judgment, if you look at how it went to the Labor Appeal Court, and at the LAC, Kiley was now represented by advocate Wim Trengrove. And his starting point was impressive because what Trengrove did was to say, all that is going to argue is if his client is not protected by the Constitution, he would cut his losses and not pursue any further. And he says the starting point is to look at Section 23, which says everyone has the right to fair labor practices. And his point was to say everyone would also cover his client. And then he gets the judge in a tight corner by saying, you, Labor Court, you started on a wrong note because you started with a public policy, but the very public policy that you started with is subject to the Constitution itself. Hence, the starting point should have been whether Kiley was covered by the Constitution, namely Section 23. Now, in the matter that I'll be discussing, when you are discussing these matters where there is a conduct that is prohibited by the law, that Standard Bank case is always very informative, which says, look, when the legislature penalizes an act, it impliedly prohibits it, and the effect of that would render that act null and void. But the nice thing about that appellate judgment is that much as the Judge Solomon acknowledged the issue of invalidity, he says, this is not a hard and a fast rule. So there's an element of flexibility that as early as 1926 is brought into play when you're dealing with invalid contracts. In a 1954 judgment, Potty versus Court, that's also another judgment as early as 1954, which actually now states that, look, one of the issues you are going to be discussing when you especially are going to determine the invalidity is to make sure that you don't produce a result that is capricious. And those who follow the developments in labor law You know the Concord in Adcon versus Steenkamp, where prior to that, if an employer issued a retrenchment notice and it did not comply with the timeframes prescribed by the LRA, that termination would be declared invalid. The TPS case, the Riven case also followed that, but there was later a change in the Steenkamp judgment said, look, that's not the point. They are not visited by invalidity. Now, one of the things that the Labour Court looked at when it dealt with this discovery was to say, more on previous occasions, the commissioners would get the easy way out by saying, okay, the contract is tainted by illegality, then the CMA would not have jurisdiction. And when the Labour Court commented, it was Judge Andre van Riebeeck on this matter, he says, look, this commissioner went the other way. And he actually appreciated by saying, look, he didn't choose the easy route of just saying, okay, the contract is invalid, and on that basis, we have no jurisdiction. And if you watch the space in labor law, for quite some time, the Labor Relations Act would say dismissal would mean termination of an employment contract with or without notice. But if you look at it now, it's changed now to say termination of employment with or without notice. It was a way in which the LRA was sort of saying, let's run away from these validity and invalidity debates when it comes to employment contracts. So one of the things that the judge tackled in the discovery matter was to make reference to ILO Convention 143, which in a way tries to deal with this issue of clandestine migrations where those employees, because of the fact that there's some legal issues that create problems for them, they would not get any employment contract, rather any employment protection from the courts. And then he, in a way that's not important for this debate, made reference to the Badebop versus Numsak judgment, say, look, the starting point for the courts, when you interpret Section 23 of the Constitution, is to always have regard to international law. So, to cut the long story short, in the discovery matter, the court holds that notwithstanding the fact that the work permit was not valid, the aggrieved employee was an employee and was entitled to protection under the LRA. And typical of Judge van Niekerk, he made the point of saying, I know some of you as cynics will say, I'm encouraging illegality, but he twists the argument around by saying, in fact, if employees who do not have valid work permits are protected by the law, it may actually discourage employers from employing them because they would normally take advantage of the fact that since they don't have work papers, valid work papers, their disputes would not be entertained by the court. So he says, I'm actually doing the right thing. I'm actually discouraging illegality here. Let's bring it now, there's something called charity begins at home. This judgment comes from the Tata High Court Division. It's a very interesting set of facts, like Justice Motsanega would say, a little bit of history helps in contextualizing issues. The applicants are Congolese foreign nationals. They were employed by the Department of Health in the Eastern Cape as medical officers. One thing that sticks out, they were neither South African citizens nor permanent residents, and that will come out when we discuss the controlling law in the public service. So now, the Public Service Act, Section 10, is very clear. You may not be employed on a permanent basis unless you are a South African citizen or a permanent resident. And these 4 medical officers were neither South African citizens nor permanent residents, but the district manager concluded permanent employment contracts with them. And naturally, those contracts were in contravention of the Public Service Act and even the policy on utilization of foreign nationals. You follow the facts. The district manager appoints them on a permanent basis in 2020. Then on the 11th of May 2023, out of the blue, they receive notices of termination of their employment contracts. And the argument of the employer is to say, your contracts were of a limited period of 3 years. You can see now, even though, like I said, when I take you through, you'll see what the employer was trying to avoid here, because there had been a breach by the district manager of the Public Service Act and even the National Policy on Utilization of Foreign Nationals. So now when they approach the court on an urgent basis, challenging the unlawful termination of their employment contracts, and the department lodges a review to say those contracts were permanent, were actually tainted by illegality. And what the judge, I think it was Judge Stokota, did was to issue a declaration to say, look, whilst this matter is being canvassed through the courts, these employees would continue to be employed on a month-to-month basis. Now, when the department takes this matter on review against the claim by the employees that looked at this matter, they say, look, you guys are neither permanent citizens nor permanent residents. And on that basis, your contract, which was permanent in nature, was void ab initio, because you didn't tick the boxes. Now, I've already touched on the controlling law, which clearly says you will not be employed on a permanent basis unless you are a South African citizen or a permanent resident. The policy also said the same thing, but saying you couldn't really be employed on a permanent basis. And the policy said if you are a foreign national, you could be employed on a temporary basis, or should I say fixed-term contract. The policy on recruitment of foreign health also said the same thing by more or less saying you can't really be employed on a permanent basis. And the 3 years there is listed. So you can understand now why, when the contract is concluded in 2020, then on the 11th of May 2023, the department issues termination notices to say your contract was due to a fraction of time. And what's interesting when you look at the case is that the letters of appointment of these foreign nationals who are neither South African citizens nor permanent residents was your employment is of a permanent nature and is in terms of the Public Service Act 1994. And we've just looked at Section 10, which says you cannot employ a person who's not a foreign national, rather who's not a permanent citizen, a permanent resident, or a South African citizen on a permanent basis. And you must also appreciate the department's gymnastics there. Because in dealing with the issue, A is clear there. Your contract is of a permanent nature. Now, the affidavit that is deposed by the HOD that says, you know what? When your contract was loaded on the PERSAL system, we, out of the blue, detected that the contracts were for a fixed-term basis, fixed-term period, and were loaded as such. That is classic self-help, to change the contract whose forward was permanent basis and change it to say we detected it and we loaded it as a fixed-term contract. So those are the gymnastics, but like they say karma has a way of coming back. That submission came back to bite the department big time, because the contract was loaded on the system in 2020, and the review on the basis of legality is lodged in 2023, 3 years later. So now the unexplained factor here, the delay. So now, the argument of the department was simple. These employees are not South African citizens. They are not permanent residents. And on that basis, their contracts were void ab initio, they were unlawful. The applicants naturally say the starting point is if you are going to interpret these contracts, interpret the provision of the Public Service Act, have regard to the employment context as well as what the court said in Discovery Health versus CCMA. So what the employees do is to say, if you look at the Public Service Act, it does say that a foreign national, rather only a South African citizen or a permanent resident would be employed on a permanent basis. But they say there is no way in the Service Act where they say if a foreign national is employed on a permanent basis, that contract is invalid. So there's no way that is said there. And they go back there to that standard bank judgment which says, even if an act prohibits certain conduct, that's not a hard and a fast rule. So they rely on that standard bank judgment. Obviously, when the High Court in Tata now has to make a call, they've got to look at Section 1, which talks to the principle of legality. And naturally, the court has to make reference to a plethora of constitutional court judgments, like that Fed Life Assurance, which actually says, when you exercise public power, you must make sure that you conduct yourself in a lawful way. And it also goes on to say, when you exercise public power, you can't exercise powers that you do not have. You can't act ultra vires. They make reference to another judgment, the Merifon judgment, which says, if you talk about the principle of legality, it's firmly endorsed in our system. And that if you exercise public power, you must have respect to the prescripts that are applicable there. That's another judgment by the Concord, which also emphasizes exercising public power, and that what is central there is the principle of legality. Now, the High Court starting point is to say we're dealing here with an organ of state, and the principle of legality is sacrosanct. And what Judge Ragunanan says is, this is a very simple matter. The Public Service Act is clear, Section 10. Only certain categories of employees may be employed on a permanent basis. And it says, if the applicants prove that they are South African citizens or they are permanent residents, then it's case closed. If they can't jump that hurdle, it follows that I have to review the appointment on the basis of legality. And he buttresses the argument by saying a state is entitled to review conduct of its own, which is tainted by illegality. So what he does is to make a finding that the contracts were in violation of Section 10 of the Public Service Act and also the national policy on utilization of human resources there. And he also goes on to say that district manager acted ultra vires by appointing people on a permanent basis, whereas they didn't tick the box of being appointed on a permanent basis. So what Judge Ragunanan says is that this case involves an organ of state, and it must be distinguished from the Discovery Health versus CCMA, which did not involve an organ of state. That statement appears to be seductively appealing, but it's got lots of questions. If you refer to the Concord judgment of Chirwa versus Transnet. There's paragraph 66 there, which says, in terms of the new dispensation under the LRA, there's no differentiation between the treatment that is accorded to the state as an employer and other employers. They should be treated in a similar fashion. The matter is taken on appeal, and now it's the full bench. I think it was Justice Lang, Justice Zono, and Justice Watt. And the court does not struggle to say, we agree as the full bench with the decision of the court, the High Court there, that these contracts were invalid because the requirements of Section 10, that box had not been ticked. And they also say, we agree with the court aqua. The issue here is, this is an organ of state, and it's distinguishable from the Discovery Health judgment. But then, there was an elephant in the room, the delay. Remember now, the contracts are concluded in 2020, and the department lodges a legality review in 2023. And remember, the HOD has tied herself she has boxed herself into a corner there, because she has said, when the contracts were loaded on the PESAL system, we detected the wrongfulness, and we adjusted the contracts to be on a fixed-term basis, self-help. And obviously, the issue now was, what would be the department's answer to the aspect of delay? And on the facts, there's none. And now, what the court does is to make reference to a 2006 Supreme Court of Appeal judgment, which says, look, where the delay is unreasonable, then there must be an inquiry around all the facts and circumstances. And once again, what the court does is to say, look, the mere fact that there's a delay, it doesn't mean that it can just be overlooked. The court must now exercise discretion. And this is one judgment that the courts, whenever they have to talk about the delays, make reference to the Kumalo versus MEC for Education. The facts of that case are very interesting. There's a position that is vacant, the department advertises it, and they say, persons who will be considered for appointment or promotion, whatever you call it, should have a grade 12 or a senior certificate, and should be having experience at level 6 and 7. But guess what happens there? Mr. Kumalo, who's at level 5, is shortlisted and appointed. Mr. Ritchie, who's in level 7, is not shortlisted. Naturally, Mr. Ritchie complains because he has seen that Kumalo didn't really meet the requirements. There's a grievance that he lodges, and eventually there's a settlement at the bargaining council which amounts to a protected promotion. Another union in the sector raises an issue by saying it's complaining about its 11 members, and the basis of their contention is to say this process was tainted by a lot of dodgy things. People who are not supposed to be shortlisted have been shortlisted. Now, what happens is, in dealing with this conundrum, the MEC for Education says, I'm taking the department's decision to grant Mr. Ritchie protected promotion as well as Kumalo, the post, on review. 20 months delay, and the comments that are made by the court, because the court went out of its way to try to be fair, but as a result of the delay, it was difficult to get documents that were used during the selection process. And that is why the Concord now lays down factors that must be considered when you deal with delay. And one of the things is the potential prejudice that will be impacted on the affected parties. And you can imagine now, in this case of the of these 4 Congolese medical doctors, naturally, when you've blend and you apply for and then you are told you are employed on a permanent basis, you would arrange your finances accordingly. And now to be ambushed in May and be told that your contract is going to come to an end, it's going to severely prejudice you. And the Concord also said, you have to look at the nature of the impugned decision. And also the conduct of the applicant. And keep in mind that the department didn't come to the court with clean hands because they had unilaterally changed those contracts, which were permanent, whether rightly or wrongly, into fixed-term contracts. And so that conduct was always going to come back to bite them. I've already taken you through the Kumalo judgment summary, wherein now the Kumalo judgment is all about Section 237, which says all constitutional obligations must be performed diligently and without due delay. And I normally say, I'm married to a politician, I normally say to my wife, whenever you make a challenge about service delivery and there's some issues about delays there, use this Kumalo judgment. All constitutional obligations must be performed diligently and without undue delay. I think that should be. Now, what the court does, as I wrap up, is to say, let's look at Section 172B. The court has a discretion to declare conduct invalid and to also order a remedy which is just and equitable. So what the court does now is to say, remember this contract, it was from 20 to say, look, we'll allow it to run and suspend the declaration of invalidity until 31 December 2025. You could presume that to make sure that these doctors arrange their affairs. And in the process, they'll be allowed, they'll be entitled to all the benefits and salary payment that they would have been entitled to. So that's how they sort of deal with this issue. What are the takeaways? Particularly for organs of state, that principle of legality which binds us as constitutional democrats is always going to loom large. What we seem to be getting from this judgment is that Discovery Health is distinguished now from a situation where the employer is an organ of state. What you also get as a takeaway is the impact of delay. And you know it from our last year presentation that Toyota Motors versus Sesame states it clearly that any delay in labor matters undermines the primary objects of labor legislation. And you know how the employer had a good case in Stokwe, but was punished. They were hit with costs, and they were also hit with an order that the dismissal of Ms. Stokwe was procedural unfair on account of the delay. All of us were waiting with bated breath because all along we've known Discovery Health to be the locus classicus. So we're all hoping, because the employer was actually keen on taking the matter on appeal to the SCA, and we all thought that it would end up in Braamfontein with the Concord. But then the SCA declined leave to appeal by saying there's no basis of an appeal here. So it ends there. But as we argue, typical of scholars, that organs of state must be distinguished when it comes to the application of the principles that were distilled in the Discovery Health. That's my ending note. What about what was said in Chirwa? On what basis can we argue, just to expand on Chirwa, that an employer in the private sector cannot have a provision that says if you are absent for 5 days, you are deemed to be discharged You can't have that in the private sector. But in the public sector, that seems to happen. What about what Square says in Shiro? That's my story, and I'm sticking to it. Until you prove me otherwise. Thanks. Sure.
Thank you so very much for that presentation, Mr. Kotoi. It's very informative. Thank you very much. So now we'll be getting ready for our question and answer session. Sure, you can grab. Let me just bring it forward for you, Mr. Israelson. I think we need to, let me just wind it up to this side so you can be able to join us. So, okay, sure. Ladies and gentlemen, do we have some participation from the floor? In the meantime, let me just, okay, there's one there. See one at the back. Do we have more? Okay, there's also another one here at the front. Yes, sir. Thank you so very much. And maybe, Mr. Kotoi, just before, this lingers away, in your presentation, I think you sort of alluded to courts seemingly having to reconcile the principle of legality with labor law protection, especially when dealing with unlawfully concluded employment contracts. Just how should decision makers, some of whom are actually seated here with us today, approach the termination of such contracts without infringing on the individual's rights to procedural fairness, especially where the employee may not have been complicit in the irregularity in the first place?
I'll take a cue from Prof. Adebal. Normally says the best answer to those kinds is to say, and I'll lean on you, Israel, to say, make sure that you follow the law to the letter.
Yes.
Then you will not face any challenge. And I accept the proposition that law is technical, but all that the LRA requires you is to make sure that your dismissal is procedurally fair, which in a way, I think that's been the theme of the day. You give the employee an opportunity to tell you what happened, to present his or her version. On the substance side, it's whether the dismissal is for operational reasons, incapacitated misconduct. And in the cases, and I think in the case that I've discussed, what you begin to see is a situation where employers would hide on a technicality, to tread on your field, in the sense that where you've employed an employee, and in many cases, if you've been, luckily I've worked at the investor vendor, if you go there, it's always easy to get an employee without the requisite papers from across the river in Limpopo. So in many cases, many employers would knowingly employ those employees, knowing that they don't have these valid work permits and all these type of issues, knowing that it will be easy to dismiss them on the basis that the contract was tainted by illegality. And like Israel was saying that the founding principle of labor law is social justice. And one may not like it, but labor law is a little bit paternalistic. It comes to the rescue of an employee. And as Otto Confront, the Doing Labor Relations says, that the employment contract should not be treated like your ordinary contract, because it's a contract which is characterized in many cases by inequality. One party has resources, another party does not have resources. On that basis, that's now where the law must kick in to provide some semblance, I must say, with respect of protection.
All right.
I don't know if I've had it. I've taken your question like a politician, leaving you more confused than you were.
No, we're still fine. We're fine. Let's move it straight to the floor. Yes, ma'am. Go ahead. Just a short intro and just a mic on your mouth, just so you're audible. And can I ask you to stand so the cameras can pick you up? Thank you so much.
Thank you. Thank you, sir. My name is Joyce Nkupani from the Essential Services Committee. I just have two questions and for the two last speakers, I think.
Okay.
The first question relates to that Britney versus the department case. And my question is, it's just out of interest, when you indicated the remedy that was given, it was compensation.
And I just wanted to know whether, did the applicant not want to be reinstated? And if the applicant wanted to be reinstated, why was reinstatement not ordered in this particular matter, given the fact that the dismissal was found to be unfair? That's the first question. The second question is for Mr. Kutoi. And I think I just want to understand, particularly when we look at discovery and this matter, very interesting judgment that you took us through now. Could it not be the reason for not applying Chirwa and the principles in Chirwa? Could it not be that been an issue of employment? I mean, the CCMA says, but because the contract is terminated by illegality, therefore there is no contract of employment, you know, and therefore could it not have been, because here it doesn't look like the issue of whether there's an employment relation, whether there's a contract between these parties was an issue, but rather in terms of whether you can, you know, there was no issue about employing them, but rather it was the period. So the state was not saying that we can't employ them, but the state was saying we've employed.
To that, I hope you also taking notes of the questions, just so we collect them and then come back for some answers. Okay, there's another one there right at the back.
CTU, ATU, allow me to express appreciation for the presentations and the panelists. I just want to clarify the issue around the Polokwane local municipality. In addition to it, it refers to the premature referrals of disputes. My reading of recent case law suggests that when we speak of premature referrals, the wording used is final on the Polokwane matter. Thank you.
All right. Do we have another hand? Yes, on this side. Yes, right there. Thank you very much.
I'm Sumguni from Eastern Cape. No, mine are maybe very general questions. The first one is just, I just want to hear the panel, all panelists' views on the tendency by employers now in the public sector, of course, not to appoint after all processes have been followed.
Pardon?
Not to appoint whilst all processes have been followed to a point where a panel had made a recommendation. What the employer would to say, all of you were not successful, no reasons, and then it ends there. I just want your advice on how that could be taken forward, given the jurisdiction by various councils, but also the fact that approaching courts in this country also means the strength of your own.
All right.
I'm just raising that. The second thing that I just wanted to make a comment on the very same issue of the provisions of PAM in as far as the constitution of the interview committee. It doesn't, to me, make it have some experts. It simply leaves it to the discretion of the HGP, which in my view has the potential to undermine the interests of children. Remember, if you are looking for a history, geography teacher and so on, somehow those who interview this geography teacher or history teacher at least must understand the field and the complexities of the field, so that you see that whoever you brought in or you bring in does have that. The same with school principals. You know, you'll find that it's very common that people with no experience at all in management, but because they can theorize around all these other issues about management,
right,
they impress those HGPs and then they get appointed. I want your views as to whether it is not time that the current policies be revisited in such a way that they put centrally the interests of children.
Sure.
Thank you very much.
Okay. Okay. Anyone can go first.
I think
Prof.
I
van
can.
der Walt?
Yeah, thanks, Joyce. That You referring to that matter, as far as I recall, but I now speak under correction, when I read the award, the applicant, there was no second respondent joined and the applicant wanted compensation. So that's why also, in some of these cases, these latter cases of, well, really 2 or 3 of them, the issue was really that I thought, well, this is substantively unfair and the applicant could have asked for the setting aside of the appointment and actually be appointed. But not in one of the arbitration cases that happened. So I'll have to check up on that, and I can do that for you. We can discuss it, but I believe that was the case, that was the circumstances in that particular case. That was the one for me, I think the first one for me, and then there was your second question was not for me.
Yes, Mr. Elrc, yeah. Go ahead.
I think if I make a general comment, explain a basic principle, it'll answer quite a few things. We've had cases here where employers have been caught between complying with one piece of legislation that conflicts with another piece of legislation. And that's a kind of a tightrope. Because labor laws supported by the Constitution say we must look after the rights of employees. And we've seen how many cases have been decided of this nature in favor of employees. But that only looks at half the issue. We have to look at the other side of the coin. If, for example, an employer suddenly discovers that one of its agents has employed people illegally, for example, in terms of the Immigration Act, that problem cannot be swept under the carpet. It has to be dealt with. If it isn't dealt with, it means that the employer will be prosecuted, for example, by the immigration courts. And if they don't carry out the order of the court, which is to terminate the employment of the illegal employees, they'll be prosecuted. And if they don't carry out that order, they'll be prosecuted again and again. So it's not something that can just be left hanging. The employer would therefore have to approach the employee and say, look, unbeknown to us in senior management, somebody down there employed you illegally. We now need to implement an incapacity process to try and resolve this problem in a way that will be fair to you. What that will do, it will then comply with labor law, but also with immigration law, because the employer would say, we've got no problem with your work, with your performance, with the fact that you're employed per se. It's just that this happens to be technically illegal, and we have to resolve that. So we would like to give you an opportunity of X weeks or months to try to get the correct papers. We will work with you in trying to do that by approaching the Department of Home Affairs, for example. So you're now following an incapacity process whereby you're proactively trying to resolve both problems rather than solving one of them and sweeping the other one under the carpet.
All right.
Perhaps I can just add to that. Would you want to first?
Oh, no.
No, I've
Go ahead.
spoken already.
It's fine, you can take it. We'll bring in the doctor.
I support that approach. I mean, if you read the Discovery Health case, the variety of the case is actually that the immigration legislation does not cause the contract to be invalid. It's visited with criminal sanction. So that would be both the public and private sector, but now the Public Service Act has a provision which makes it different for public service employees. But I do believe that's really what social justice is, and that is what the CCMA would require. That is a dismissal, and the employer must comply with the requirements of incapacity dismissal. I fully agree with that.
Sure, Doc.
On the issue of Polokwane local municipality versus Salga Bargaining Council, the citation is 2008 and 8 BLR 783 Labor Court. And obviously the dispute or the issue of premature referral arose from the municipality's argument that the employee had referred the matter to the bargaining council prematurely before exhausting the internal processes in terms of the collective agreement. And they said, no, you skipped 3 steps that are required internally. And that was the issue, but the Labor Code found differently.
All right, Mr. Kotoya, I know there was also a question that came up from the floor for you as well.
Yeah, there was one that was directed at me.
Sure.
And it was this, this Discovery Health and the argument by both the High Court and the full bench that the case that was before them was distinguishable from Discovery. And one of the things that, if you read that judgment, the only line that you get from the judgment is that this is distinguishable. This Discovery is distinguishable because here we are dealing with an employer who's a state department and thus an organ of state. So as for the issue about the contract, I think we've all come to terms with the fact that there was a contract of employment that was concluded between the Department of Health and those 4 medical officers. And like we went through the forward, it said your contract was of permanent employment. And one of the things that the court there canes the department is you want to discontinue with these doctors and you don't have local skills to occupy those positions. And in the judge, especially the appeal judgment, it says you are now compromising, you are now creating a skills deficit there because there will be no one. And it is one of those rural hospitals in Port St. John's. It's a Limela hospital. So it's one of those, like I said, we can argue about it, but the courts don't really assist us by saying we are distinguishing it from this. Okay, we can only draw an inference by saying, look, in this case, there was the Public Service Act, Section 10, which says you may not employ a person on a permanent basis. And the interesting part, Lang, who wrote the appeal judge, says, look, as to why there's this distinction between permanent residents and foreign nationals, he does create by saying that may also be subjected to some scrutiny. But he said that was not the matter before him. So the court is its own enemy by not telling us in clear terms as to why Discovery Health must be distinguished when it comes to its application in the public service. And for me, like I said, the last line about Shiro is just to play the devil's advocate to say, what about if someone says, why is the state getting this extra layer of protection when it comes to those issues?
And from what Mr. Koto is also saying, Prof, I get a sense that there's some sort of a balance that must be struck, right?
Yeah.
And how do we go about that?
Why me? Yeah, it is, what happens is purely that there is the legislation that's only applicable to public service. That's actually the legislation that stops it. There's not general legislation. The general legislation is, well, that's what Judge van Niekerk said, that criminalizes it. So deal with it as a dismissal. And that then was even taken further in the Kali case. So even if, Judge van Niekerk said, even if he was wrong, and it was an invalid contract of employment, the B part of the definition of employee still covers that person by saying any manner assists the employer in the business of the employer. So that's more applicable in the non-PAS. There's certain further requirements that set the bar higher for public services. Sense of the legislation that applies to it. So it's not completely balanced, that is so. Yeah.
All right. Do we still have some more participation from the floor?
There's one more that I need to answer.
Yeah, we'll get to that just in a moment. Any more participation?
No.
We're done, we're good?
Okay.
Okay, go ahead. Prof.
Not me.
Mandapati.
Okay, the best
On
interest
the
of the
best
child,
interest, yes.
Mr. Mchunu, that's very important. The best interest of the child principle is of paramount importance. So it is a factor that must be considered educators as well. So the example you use is absolutely a very good example. Why would you promote a person? I mean, I had a case like that from appointment in a junior school, in a primary school, where there were excellent, very experienced teachers in the junior primary. Another employee was not qualified for the junior primary sector, was put to act as a junior primary sector by the principal. And then when the appointment happened, she's not qualified, she's got no experience as a junior primary teacher, but she became the HOD. So that was one case where I set it aside and said, no, the other lady must be appointed. You see, so that is also, that's in the best interest of the child. So
the best interest of both the teachers and the children.
So you
Sorry
good.
about that.
All right, Doc. Last word, gentlemen. Let's go ahead. Maybe let's segue. Let's start with you, Mr. Elrc. Let's get your last word as we wrap our conversation up.
Yeah, I just need to again remind employers that the entities that look after labor laws take the requirement for social justice extremely seriously. And that's why it is important for employers not maybe one person who knows a little bit about the law working there. Everybody who takes managerial decisions that affect employees, even if they also affect learning, have to understand well. That is of primary importance. You will not get away with having a slight understanding of the law. You have to have a full understanding of it in order to be able to walk the tightrope that I was talking about earlier.
Final thoughts?
No, my last one relates to the case I discussed, because you can see that it's the district manager who created the whole chaos there. And I've been following the developments there, because that would amount to negligence, and I understand that she's never been charged for gross negligence. Because that has cost the department really big time. So surely if it was another ordinary employee, there would have been ramifications there.
Yeah.
Interesting.
Yeah.
Prof?
I just want to repeat my warning to the trade unions. Don't let the legislature take away hard-won rights that you fought for over the last 30 years by the stroke of a pen. Speak to your people at Nedla.
Doc?
Eva, Prof.
We're wrapping it up. Let's
Yes,
get your final words.
From my side, in terms of the Crow case, honestly, it is that there's a new issue that needs to be discussed, either at the level of the department or the level of the Elrc, the issue of how do you apply the issue of affirmative action in terms of equity versus merit. That case to me is very, very important because are you using the issue of equity as a tiebreaker? Or you have got to use it fairly and justify it in terms of how you use it. And that is being raised very critically there, and I think it's something that has to be looked at.
That's right. Perhaps can I just say one thing? In the Crow case, on the merits, had the department provided proper reasoning and, in fact, testified at arbitration about why the lady was appointed, they would have not lost that case.
All right. My issue is that if you have a situation where you say 25% is for experience and 25% is for qualification, 25% is for performance in the interview, do you then have to bring and say, I give you a total of 25% for equity, and that's what has been raised? And that has got to be looked at in terms of how reasonable it is. What adjustment you have to make to ensure that in the Section 195 of the Constitution is still followed in terms of affirmative action. Otherwise, it can be abused by the employer as well. So it can also undermine affirmative action if it's not going to be debated properly moving forward.
It does.
So, yeah.
And I'm glad we started this conversation here.
Yeah.
Going back to that, point of balance as well. Ladies and gentlemen, I must thank my esteemed panelists so much. Dr. Mugwena Maluleke as the General Secretary for SARTU, Professor van der Walt from the Nelson Mandela University, Mr. Israel Stem is CEO for Labor Law Management Consulting, Mr. Kotoy is from the Nelson Mandela University. I must thank you so much for your insights. The GS is going to step forward for the prize giving. And a round of applause once again, ladies and gentlemen. Doc, always great chatting. No, all good, all good, all good, all good. All right, nicely done, ladies and gentlemen. Just a round of applause one more time. So this ultimately concludes our engagement. Thank you so much, Doc. This concludes our day one today. It's been such a joy being with you today. But of course, we're going to give you about 15 minutes just to go freshen up and come back, because there's going to be a smaller cocktail networking session just so we get acquainted. No freshening up. Okay, so just straight into it. Okay, perfect. Okay, so ladies and gentlemen, I'm told straight after this, there's going to be a networking session where we're all going to get acquainted just to, unwind and talk about the day's proceedings. Otherwise, you've been such a joy to be with today. I'll see you tomorrow here, bright and early at 8:30 a.m. Enjoy the rest of your evening. Cheers.
Labor terrain is shifting faster, deeper, and more complex than ever before. And when the landscape changes, leaders must rise. Join us from the 11th to 13th of August 2025 at Empress Palace in Johannesburg for the Education Labor Relations Council Labor Law Seminar, under the theme, Adapting to an Evolving Labor Landscape to Promote Social Justice. It's a strategic gathering of policymakers, union leaders, educators, and legal experts converge to chart the future of work, rights, and equity. Education Labor Relations Council Labor Law Seminar 2020.